water main be deferred 2 weeks to allow staff to bring forward further details. May I have a motion to approve the agenda as amended? Councillor Martin, and seconded by Councillor Taylor. Any discussion on that? Councillor Michelli.
Yes, thank you, Madam Mayor. The item, that's what I was just kind of looking for, the item. Regarding gas well updates.
It's okay, don't worry about the...
Well, I'm just looking for, anyway, Madam Mayor, if we can, when we are discussing the gas well situation update, I believe we have a member of the community closely connected to that would like to speak today.
Okay, so Brian Craig had reached out, who is one of the homeowners that's been affected by the gas well that's leaking on county property on Forestry Farm, and he was just hoping to address council for a minute after Marlene presented her report. So I guess if we could, we'll approve, should we take a 2/3 majority on that one?
No, it's still under the changes to the agenda.
Okay. So, sorry. I can't remember who moved that to begin with again. Councillor Martin and seconded by Councillor Taylor. All those in favor? And that's carried. For our consent items, we have 2 items of consent. Does anyone wish to pull any of those for discussion? Okay, in that case, I have a motion that's been moved by Councillor Rabbits and seconded by Councillor Van Passen that consent items A and B be approved as recommended. All those in favor? And that's carried. And next we're moving on to our presentation from John Mascaron regarding our code of conduct and conflict of interest training. Mr. Mascaron, welcome.
Good afternoon, Madam Mayor and members of council. I'm back. I'm going to do some education and training for you today. Madam Mayor, I expect to be, I don't know, depending on questions, hopefully about an hour and a half. I'm in your hands. I usually try to run these with a little bit of informality so people can ask me questions, but Madam Mayor, whatever you would like, I'm happy to wait for questions at the end, whatever suits you.
No, that's fine. If you'd like to ask questions then as you go.
I would prefer that. I think it makes it a little more interactive and engaging.
Sounds great.
Thank you very much. And will the clicker work? Am I supposed to point it in a particular direction? Oh, terrific. Thank you. Thank you. Is it on? Oh, it works. Fantastic. Thank you. Thank you. My introductory presentation will be on the code of conduct in general, what it entails in general terms, what my authority is as Integrity Commissioner, and again, I would welcome any questions that you may have as I'm going through this. The second part of my presentation will be on the Municipal Conflict of Interest Act, and once again, I welcome any questions that Council may have of me, and I'll try to keep looking up to see if I can spot if you've got your hand up. So, the Code of Conduct, it's now mandatory. As of March the 1st, 2019, the province has dictated that every municipality has to have a code of conduct. Before this date, it was strictly permissive. The only municipality that was required to have a code of conduct was the City of Toronto, and that's historical, arising from the MFP inquiry in the early 2000s and Madam Justice Bellamy's report on that. Section 223.2 of the Municipal Act, very clear, municipalities shall establish codes of conduct. The code of conduct is established by council, and it has to apply to both members of council as well as to local boards. So that's new. That was never there before. Your code of conduct does apply to both members of council and local boards, so it's compliant at least with that requirement. What is a code of conduct? Well, it's a policy, a guideline, a protocol, however you'd like to describe it, that sets the ethical framework, that sets out established standards for which council is required to adhere to. It's not an encyclopedia. My former colleague now, Madam Justice Leeper, always used to, when we present together, she'd always say it's not a cookbook. You can't look it up and find every particular instance of wrongdoing that you can point to and say, there it is. It's a set of standards that are applied, and how are they applied? They're applied by you in understanding how the code applies, and then of course I have to interpret it and look at a set of circumstances and apply it in that case. In my view, a code should have at least 3 criteria. It should be credible. It should not be just a purely skeletal code that's laughable and that someone would say, what does that regulate? It should be useful for the public, useful for members of council, and functional. So it can be easily applied to a set of circumstances and actions. There are now also mandatory subject matters. The province, Minister of Municipal Affairs and Housing, last February prescribed 4 mandatory requirements of a code of conduct, pretty minimal standards. The province, I think, was concerned that some municipalities wouldn't create credible codes of conduct, so what they did is they said, well, at least you have to have these 4. But notice what it says is it just has to cover these 4 subject matters. The province doesn't tell you how you have to cover it. All it says is that you at least have to cover it. My view is if municipalities don't cover it appropriately, you might see the province coming back and putting in some provincial oversight and dictating a little more specifically what municipalities should do with their codes. Now, that would be retrenching the law in municipal law over the last 25 years, where the courts, the legislatures have deemed it appropriate for municipalities to run their own ship, mostly, steer their own ship or row their own ship, whatever the saying is. And that's why you have prescribed subject matters, but it doesn't tell you exactly how you're supposed to apply them. And notice that the regulation authority is at the bottom there. The minister may make regulations providing for other subject matters. Yes, Madam
I just
Mayor.
have a question. So I think I read at some point that you were involved in the drafting of the code of conduct. Is that correct? Or that the integrity commissioner RFP stated that you were going to be involved in that?
I wasn't involved in the drafting of this code of conduct, the one that you have that was passed last year. I certainly can be involved, and it's typical that if you have an integrity commissioner, the integrity commissioner will be involved with the drafting or at least advising whoever's in charge of putting it together. I have drafted codes for a number of other municipalities, most famously for Niagara Region, when I walked into, after the 3rd public meeting, I walked into the 3rd public meeting and I was handed my code of conduct with the comment by a former member of council, we made a few changes. There were 58 specific changes that amounted to 238 specific changes to my code. I said it was actually, I think I said it at the meeting, it was laughable what they had done with it. I think now Niagara Region is actually going back to my original code. I was advised by the clerk that they're re-looking to put in my code. So I didn't have a hand in this one, Madam Mayor.
The reason I just asked, I know that you had done some work in Lambton, so there was a couple spots in here that it talked about interpreting good faith in the context of Lambton County, but that probably came from somewhere else. But a few people had mentioned to me, I've heard it before, of maybe adopting a more modern day code that would include, because this doesn't include things like social media and those kind of aspects, that may be something that we should consider down the road. And hopefully get your involvement in it. of
Well,
course.
thank you, Madam Mayor. And I'm sorry, I didn't mean to interrupt you. I would like to be involved. I can tell you that just today, right after this meeting, I'm actually going to a municipality that I've just been appointed as Integrity Commissioner. And what I did is I prepared a code for them. I have what I call a best practices code that I started developing a couple of years ago that I keep changing it every time I put it together, because I always get great comments back, either from members of council or from the public, and I always feel that there's some improvement in it. So I can certainly, again, I would be happy to help you with that. And I like to think it is a more modernized code. For instance, this code here doesn't really even talk about non-pecuniary conflicts of interest. It only talks about pecuniary interests, which I think most codes have moved away from, and they've said, no, you have to cover off personal, private conflicts of interest, not just pecuniary interests under the MCIA. Your code, I'm not going to go through it in any detail today. I've just outlined for you the specific provisions up on the screen. You'll see that the ones in red are the ones that relate to the mandatory subject matters that are set out in Regulation 5518. Now, the one that'll probably strike you there is general duties. Well, what's that? But in your general duties, subsumed in that are certain things that are covered off in the respect for staff requirements of the new the mandatory subject matters. So that's under what's called the general duties, and you'll see gifts and participation at events. Gifts, hospitality, benefits is one of the prescribed subject matters. And I'll quickly just turn. There's two more here: the use of county property and confidential information. So your code, in that sense, is at least compliant with the mandatory minimum requirements. But I'll be frank; it is a little lacking in some of the other things that I would certainly recommend for some modification, including the complaint protocol. And I'll get to that in just a moment. The use of county property. Just let me say, it's not just of real property. I think that's a lot of people get that confused. I recently have, I think on my desk, 4 complaints on misuse of corporate property by municipalities. And it does include things like official marks, the logo of the municipality, insignias, things like that. Those are all property of the county. Those are not things that council members can necessarily use or appropriate as their own. So I wanted to be clear. There's matters dealing with communication, municipal election campaigns. That's something that you really should worry about in the 4th year. It doesn't really, I think, apply at other points during the term. The one that kind of struck me as a little odd is conduct of former members. There's no jurisdiction in the Code of Conduct Authority under 5.1 of the Municipal Act to actually regulate the conduct of former members. So I'm not sure if this is actually an enforceable clause. I'm not really sure what else to say about some of the other ones. They're pretty obvious when you look at them. Things like conflict of interest, again, it really only deals with pecuniary, and it says you have to look at the Municipal Conflict of Interest Act, the second part of my presentation. My view is I think it goes much further, and I'll speak a little bit about that in just a little bit. So, integrity commissioners, let me speak about myself. I'm a statutory officer, and I report directly to council. I don't report to anybody else. I don't report to the CAO, the clerk, the solicitor. I don't report through them in any way. I exercise my role independently, and I function independently. Council set some groundwork for me by the IC appointment bylaw, by the complaint protocol, but in most respects I deal and undertake my work independently, and I'm not beholden to anyone really, and in some cases council. I report to council, but I'm not necessarily taking direction from council. Again, it could get a little complicated, so I don't want to go into the minutia. The functions are assigned by the municipality with respect to the Code of Conduct and the Municipal Conflict of Interest Act, and there you'll see a number of functions. I can advise council, and I can advise members, and I'll speak about that. I can educate members as well as the public, as well as staff, and that's part of why I'm here today. I can investigate complaints. You heard me last week on two of them. I can conduct inquiries. And if you ask me why those two words different, why is it investigation and inquiry, I'm not really sure. They're used interchangeably, but I always say investigation is complaint. It's under the Code of Conduct. An inquiry is done under the Municipal Conflict of Interest Act. But even the language of the statute isn't quite that clear. I also adjudicate complaints, and in most cases, the Integrity Commissioner will recommend penalties or corrective or remedial actions to be taken. I've been delegated the authority under your code and your complaint protocol to actually impose the penalties and any corrective measures. That's happened in a number of municipalities across the province. I think I have 7 municipalities in which I actually impose the penalties directly. There was a group of municipalities that came to me and said, we feel very uneasy. We're acting as judge and jury of our own members. Won't that politicize the process? And I said, that's a very good point. It's astute. It could. You could have people gang up on people. On the other hand, you might want to argue it is council's code. Council's passed it. Council should be the person, the entity that imposes the penalty. So you could look at it both ways. I'm indifferent. When a council says to me, we want to impose, we want to give you the authority to do it, will you accept? I said, if that's what you would like, of course I will accept. But I still think that maybe some of those functions should be council's functions to do. But I understand about politicizing the process as well. So those are the functions there. And they arise really from Madam Justice Bellamy's public inquiry report, a big 4-volume report written in this incredibly interesting style as a heightened Victorian novel, very melodramatic. You know, there was all sorts of salacious details. There was Tom Jacobek meeting in the parking lot on a Saturday night, and then a deposit to his mother's account the next day. There seemed to be a questionable relationship between Ty Domi's brother, who was giving tickets to the treasurer of the city and flying her to Florida and flying her to Philadelphia. So it was all sorts of really interesting things, and Madam Justice Bellamy took the opportunity to write it in a way that was quite readable. But what she said is an effective integrity commissioner system provides for 2 basic functions. One is an advisory service. That's when you could come to me for advice and get guidance on the Code of Conduct or the Municipal Conflict of Interest Act. And of course the other one is investigative or enforcement, which is looking at complaints, writing reports to council on systemic problems and so on. There's been a question by a number of municipalities whether it's appropriate to have an integrity commissioner do both. I see no issue with it. It's the way the federal integrity commissioner's office is set up. It's the way the provincial integrity commissioner's office is set up. I was recently talking to the city of Edmonton, who was consulting with me on how to set up their system in Edmonton. And they have a slightly different framework. They don't quite have the robustness of the Municipal Act. And they asked me this question, and I said, I don't see a problem with me giving advice, but also investigating. And I maintain that position. And yet there's a number of municipalities, I think Oshawa, Peterborough, Ottawa, who feel that there should be 2 integrity commissioners, at least 2. One to do the advice-giving function and one to do the investigations. I'm not of that view. It's integrity commissioner is a mandatory accountability officer now. A municipality must appoint an integrity commissioner, or if a municipality doesn't appoint an integrity commissioner, it can retain an integrity commissioner, can do it by contract, provided that that person or that entity, that body who's an integrity commissioner, is an integrity commissioner somewhere else. As I've noted there, Airden Burles, my firm, was appointed as integrity commissioner by the council back on January the 8th by bylaw 2019-06. I think I received a number of appointments all around that time because a lot of municipalities were waiting for the March 1st deadline. In case you're wondering, I think we act currently for about 40 municipalities as integrity commissioners. I think I lucked in a little bit on this gig, I must admit. There's, I think, 3 or 4 integrity commissioners that have the majority of municipalities in the province. I won't say anything bad about the other integrity commissioners. They're actually all quite good. The people who have been retained by many municipalities are actually very good people. We often will consult with one another on an anonymous basis and run things by other people. Most integrity commissioners are either a one-man operation or they're a small office like Principals Integrity or Nigel Belchamber and Fred Dean out of Amberley Gavel. My office has probably the largest team of integrity commissioners. I have currently 4 people who work in the team who will probably try to help you at certain points. And I think we're bringing on a 5th person just to make sure that we can cover our municipalities in a prompt, effective way. The functions of the Integrity Commissioner, and if you can look up on the screen, you'll see that there are some things in black. The things that are in black were what was there before. Effectively, the Integrity Commissioner prior to March the 1st was a person who went in and acted on a complaint basis and investigated. That's actually what the Municipal Act said. Now, most people, going back to a couple of slides ago where I said there was 2 basic services, one was enforcement investigative and the second one was advice-giving function. Most integrity commissioners, me included, read in that was part of the mandate, so we thought it was an implied power that an integrity commissioner would have, that if a member of council or a member of the local board would call us and say, hey, there's this matter coming up, do I have a conflict? Or can I do this? Would that be undue influence? Or can I accept this? I think most integrity commissioners read in that they were entitled to give advice on that. I usually checked with my municipalities and made sure that I had the advice. I didn't want to start sending them bills for something that they hadn't given me the responsibility for. Now, it's changed, and as of March the 1st, the Integrity Commissioner also now has a role, and I'll speak a little bit more about it, with respect to the Municipal Conflict of Interest Act, and that's absolutely brand new. I think that's a win for council members, because before this, and you'll see when I get to the MCIA presentation, you're on your own. You had to sort of figure it out yourself. You couldn't go to the clerk, you couldn't go to your municipal solicitor, you couldn't go to your CAO. Now you could come to me and ask me for advice. And without giving away much, I've already been consulted by a couple of members of council who have asked for my advice on the MCIA. Number 3, the 3rd bullet there, written advice to members regarding their obligations under the Code of Conduct as well as the Municipal Conflict of Interest Act. So now it's been enshrined in legislation. And the 4th one is provision of educational information. You could always give it to members of council. You could probably give it to the municipality, i.e. the staff, the administration. Now it's required to be given to the public as well. Now, having said that, I think this, having an open session of council where the public is invited, fulfills that requirement. If you're going to ask me, well, John, do you just sit there and wait for the public to call you and then they're, it's on our dime. No, I don't do that. I do answer questions if people need to know something about filing a complaint, but no, I don't generally take questions, and I don't try to encourage people to file complaints. Okay, that's a question that's often asked. In fact, if anything, I seek to try to dissuade people from doing so. There are other things that I can do, I think, to try to put forward the ethical way or the standards that are here. One is perhaps just having conversations and giving you a call or sending you an email. Sometimes I've had to do so at the direction of senior staff who have asked me to please call someone and see if they can cease and desist of doing something. One of the things that I want to say to you about the written advice to members, just look at what it says. It says written advice to members regarding their obligations. I can't give you advice about other people's obligations, okay? So you can't call me or write to me and say, hey, I think the mayor has a problem here. I want you to tell me if she's done something wrong. That's not what I do, okay? I will occasionally have a conversation to try to set out the regime, but you can't call me, Councillor Michelli, you can't call me and ask me about just picking on him, Councillor Taylor, who was so nice to greet me and open the door for me today. You can't call me and ask him, did he do something wrong? That's not something that I will advise you about, okay? But I will advise you about your specific obligations, or Councillor Rabbit's about his, Councillor Martin, but I won't talk about other people unless it's very general, and I certainly won't go, oh yeah, that's a real breach, and I have a real problem, and I want you to file a complaint. I might say to you, you might want to consider a complaint, but I certainly try not to encourage it, because quite honestly, isn't that a little bit of a conflict of interest for me? Because if I start encouraging people to come, that means you're going to have to be paying it. I just don't think that's appropriate and that's proper. So I, in fact, try to go the other way. And you have to trust me on this, because one of the things that I'm supposed to do is, of course, act under a cone of silence, which I'll speak about in just a moment. Indemnification, I just really want to mention this. It used to be quite the opposite. When I used to apply to be an integrity commissioner at a municipality, the municipality would often say, and if we do appoint you, or if we do retain you, then you have to indemnify us and save us harmless. That's not the law. I am either an officer or I'm an agent of the municipality. Therefore, I fall within the rubric of Section 448 of the Municipal Act that says, as long as I act in good faith, so as long as I don't act in bad faith, I'm indemnified by the municipality. There's an additional indemnification under 223.3, and this is something that, I'll be honest, the Integrity Commissioners of Ontario lobbied very hard to get. Because what would happen is often we would do our work, we would do our job, we would go in, investigate, find some wrongdoing or a contravention, and then say, I think you should do this, and the council would do nothing. Or then the council might do something, and then they would take me to court. And the municipality would say, you know what, it's going to cost us too much. We don't want to defend this. But it's my reputation that's at stake. This says as long as I act in good faith, and someone either complains to the Ontario Ombudsman, which you're entitled to do if you don't think I'm doing my job, or any of the public don't think I'm doing my job, they can apply to the Ontario Ombudsman and say, Mascarin is bad integrity commissioner. Haul him up, speak to him, and do something. The Ontario Ombudsman has oversight over me, over integrity commissioners. The second way that someone can challenge you is a court application, a judicial review application. I don't want to get too complicated, but the Integrity Commissioner generally reports. So a report in itself won't create a statutory decision, and there's case law that says you can't judicially review that. But once council makes a decision on it, then someone could bring the Integrity Commissioner to court. And I guess the proceeding would be Mr. Smith versus the Integrity Commissioner of the County of Norfolk. And the municipality could say, I'm not going to defend this. And that quite honestly is wrong. So I have the authority to go and defend myself, and then the municipality has to indemnify me. There's been 4 judicial review applications of which I'm aware of in the province. One I'm going to speak about in just a moment. It went to court and there's a decision. Two others, Giorgio Mammoliti in Toronto and former Mayor Susan Fennell in Brampton, took their integrity commissioners to court and then dropped them. They abandoned them. The fourth one is interesting because I'm representing the integrity commissioner. The integrity commissioner for the city of Windsor has been taken to court by one of his own council members, and I'm defending him. Advice. The advice-giving function, please don't get mad at me. There's now an express authority for me to give you advice, both under the Municipal Conflict of Interest Act as well as the Code of Conduct and any other ethical guidelines or policies. For instance, the harassment and violence in the workplace, as well as council staff relation policy. Those are things that you can come and ask me. But I will tell you, if you're asking me about these things, you have to put it in writing. And that's not me asking you this, and that's not your code. It's the statute itself. The Municipal Act requires that. Now, you can see the common sense to that, because if you're asking me questions and then you can rely on those answers that I give to you, you'd want them to be in writing so that there's no misunderstanding about what the actual question was and what the advice was. So, yes, Councillor Huffman. In my view, the workplace, so it's the county, any administration building, anywhere where the county is having business. It isn't just the council chamber. Does that answer the, yeah. Okay. So you see the very bottom note, that is so important, and that's something that I would like to enshrine in your code, or at least your complaint protocol. The member may rely upon advice if all relevant facts are provided to me and I respond to you, and then you can rely on it. That is something that I normally put in all my codes, and I stand by it. If I've given you advice on something and you follow that advice, and you've actually disclosed all the relevant facts to me, because sometimes people don't, then you're entitled to rely on it. And I've held to that standard, even if I'm not the integrity commissioner that gave the advice. A few times I've stepped in for other integrity commissioners, whether they've resigned, left, or whatever, and I've seen some correspondence, and the council member has followed to a T the advice of the integrity commissioner, and I get a complaint on the very matter, and I'll say, what more could the council member have done than to go to the integrity commissioner, get advice, and then follow the advice? So I've often dismissed on that basis. That specific clause that the member may rely upon advice is actually in the Municipal Conflict of Interest Act. And I borrow that wording and I put it in the code because I think that's important. If you're coming to me for advice and I give it to you, then you should be able to rely on it. And if I've made a mistake, if I've given you bad advice, well, then I should wear it. But it shouldn't be your fault. So, investigations. In general, the Integrity Commissioner investigates or undertakes an inquiry on a complaint or request basis. So, council, of course, may request the Integrity Commissioner to go in and research a matter, to investigate. We certainly have given general policy advice on surveillance videos, on council staff relationship matters, policies, social media. So that's where the Integrity Commissioner acts outside of a sort of a complaint basis. The Code of Conduct and the Complaint Protocol, they set out the terms for how the Integrity Commissioner investigates or inquires. There are three real components, and I'll speak about that in just a moment, as to where the jurisdiction and authority and rules as to how an Integrity Commissioner proceeds, where they emanate from, where they come from. I have a large authority to investigate. I want to let you know that. The Commissioner may elect to exercise the powers of Public Inquiry Commission. So normally, and I'll tell you, I've never had to exercise this. I usually go in and I say, I'm the Integrity Commissioner, I'm here to do an investigation. I've had compliance. I've never had anyone say, I refuse to talk to you. However, if someone does refuse to talk to me, I can constitute myself as a public inquiry commission, and I have the right to subpoena and to summons and to ask for disclosure of documents. Okay? That's a really large authority. Sub 3 there, the municipality shall give the integrity commissioner such information as the commissioner believes to be necessary for the inquiry. So this often happens where I'm asked to go and do an investigation where something went wrong, but no one's really sure what happened. The one that usually happens is there's an in-camera meeting, it's supposed to be confidential information, and someone goes and leaks the information. And for instance, this was an in-camera meeting, well, the press wouldn't be here. Truth to power, right? The press wouldn't be here, but there'd be a number of people. There'd be all of council, there'd be the CAO, the clerk, and a number of other officials. Who knows who leaked the information? I'm entitled to go in, I'm entitled to look at emails, I'm entitled to ask for phone records and find out what happened. And believe me, these things get pieced together. The most interesting recent one that's happened is in town of Innisfil, where I've been the integrity commissioner for 6 years. But I was giving Innisfil confidential information about a controversial development application at their municipality. Wouldn't you know, someone leaked that information to the developer. The municipality said, we want you to investigate. I said, I can't. I was at the meeting. I'm actually one of the people who could have possibly disclosed the information. So I have the authority to delegate. You may see that coming up on a slide. So I delegated it to Janet Leeper, now the Madam Justice Leeper, and she undertook an investigation. But what she did is she looked at telephone records, she looked at emails, and was able to put together the trail. Madam Mayor?
Thank you, sir. I just a quick question. So does that fall under our code of conduct then, the leaking of confidential information from closed session?
Yes, that's in, you have confidential information provisions in your code of conduct. They're under Part 10, and 10.1, members shall hold in strict confidence all confidential information concerning matters dealt with in camera. So that's a provision.
So I guess, I was just wondering if maybe you could kind of elaborate here. I mean, the challenge is we've actually just experienced this, I think, recently, but, where does the end sort of justify the means with how much of an investigation? I mean, in some of these instances, I think it's probably better for council to have a discussion as opposed to, maybe doing a full-on investigation that could be quite costly to the county
Sure.
on every occasion. Would you agree with that, or?
Yeah. The couple of times that I've done them or that I've been involved, and I totally agree with you. In one instance, I actually tried, it was a school board that I was acting for. I can disclose this. It was public information. The York Region District School Board, atrociously awful minister's order. Minister said this school board is rampant with racism, harassment, violence. You've got to do something. One of the things that you need to do is have a credible code of conduct, and you need an integrity commissioner next week, basically. Well, their procurement policy said that they had to go out, they had to do things. So I was recommended, and I was interviewed. I remember I was going to court in Kingston, but I was interviewed on my way there by the director of the school board and a couple of other people. And so I was parachuted in. And the first thing that happens is they're interviewing for the new director, and the Toronto Star knows who's on the short list. There's 4 people who are on the short list. The Toronto Star knows it. So I asked the chair, is the Toronto Star correct? Are those 4 names correct? They go, absolutely correct. So I had to go in and do an investigation on that. I said to them, what's going to happen here is I'm going to do an investigation. I may not be able to piece this together, and I'm going to have to interview a ton of people here because everyone then says, well, this person knows about it, so you have to expand it outward. And they still said to me, no, we really want you to do it. And at the end of the day, I guess it partly proves your point, Madam Mayor, we weren't able to tell who actually leaked the confidential information. It was very sad, and it was a relatively expensive investigation, which was really not a good thing. Yeah.
So just a further question to that. So when, I know this isn't necessarily what you do for council, but in terms of freedom of information, if something is leaked in a hypothetical that was out of closed session and now becomes subject to an FOI request, Are you able to comment on that, on how that works?
I'm not sure. So it was in camera, and then something was leaked, and someone then FOIs it. Well, then
Correct.
it's not supposed to be. It's still covered by that. Now,
But-
if the press has widely reported it, or it's out in social media, and
No.
the question is, a lot of people don't know if it's true or not. They'll hear something and they'll go. That's why I had to ask the chair. Those names that Toronto Star had, are they actually the correct names? Because if they're not, then maybe they didn't get real information. It wasn't leaked, but they were just surmising. They were watching who was going in and out. But they actually had the 4 names, so we know someone leaked it, but we don't. At the end of the day, I couldn't find out who. Now, there were restrictions there. The school board doesn't have quite the same rigor that the Municipal Act says. So one of the things that I couldn't do is I couldn't look at I could look at any phone records that the school board had, but if someone was, if a trustee was actually was using their own phone, I couldn't get to that. And if I went and asked, I knew what the answer was going to be. So,
Thank you.
yes, Councillor Huffman. Oh.
My question would be, sorry, so what you were saying, and I'm trying to get that in terms of the FOI and the closed session piece. So what if we're in a closed session, we're discussing something, and which obviously is confidential. So the next day, I emailed Mayor Chop to talk about something within the closed session because we were both there, correct?
Yeah.
Okay. But then if there is, and in the subject title of email, it says something about, I don't know, workshop, which is the code of the word that someone's looking for in terms of FOI. So can those be those emails where we're discussing something that happened in closed session then be released in terms of the freedom of information?
I don't think that they would be, because they would be disclosing the deliberation of what council spoke about at the closed meeting, and so that wouldn't be releasable. It's protected under 6(1)(b), if I'm correct, Mr. Grisel, of the MFIPA. I should have mentioned, I'm also a closed meeting investigator for like a number of municipalities. So we've recently been covering a lot of these, a lot of questions sort of similar to that. Sorry, Madam Mayor, you had a question, I think.
No, you covered it. Thanks
Okay.
very much. I just wanted to clarify that wouldn't be subject to the FOI process.
Yeah.
Thank you.
And sub 4 there says the commissioners entitled have free access to all books, accounts, financial records, electronic data, processing records, reports, pretty much anything that belongs or is used by the municipality. So that's, again, very, very broad authority for us to go in and investigate and to start asking for things. Duty of confidentiality. Just a second, I want to make sure. Got the right one, yep. Oh, yeah, Councillor Van Patten? Sorry, what does? Yes.
That list you just gave of all the belonging to municipality, does that include my notebook that I write down?
It could possibly, yes, because that's a record that you have in your possession that emanates from what? From your duties as a member of council. So I could say I want to look at everyone's notes. I've never done that, but it is possible. A few times I've been a little anal retentive, especially when I'm advising council. This is usually not with my integrity commissioner hat on, but in camera. You go in and I often will get a report and I don't want it to be disseminated. So I'd label each report with everyone's name, Councillor Martin, Councillor Columbus, and then I want them all returned to me afterwards so they can't be disseminated. But you see people, sneaking out of camera or taking serious notes. So I will often say, I think that's inappropriate, and I think that's something that the Integrity Commissioner could ask for. Duty of confidentiality, really important. Everything that comes within my knowledge of what I do as my role as Integrity Commissioner is subject to the preservation of secrecy. But notice it also says the Commissioner may, and every person acting under the instructions of the Commissioner. So sometimes this often happens, I have to have a liaison at the municipality. I have to have someone that I can go to say, hey, I'd like to see this bylaw, or was this repealed, or what resolution was passed? So I have to be able to rely on somebody, and that person would be under the cone of silence and is subject to the duty of confidentiality. There are exceptions. If anything relates to criminality, I would have to report it to the police, and so all things are off the record if it amounts to that. The one time that this did come up for me is I saw something that was completely awful. It was very close to my calling the police and saying this might constitute a hate crime. I stopped. I gave it some sober consideration and decided not to, but it could have possibly veered there. If that happens, then I have to stop the investigation or whatever I'm doing if it veers into criminality. And notice the very last point. The section prevails over the Municipal Freedom of Information Protection and Privacy Act. So anything that I do is not something that someone can FOI and get to. They can't get the information. They can't get my background work. They can't get any materials that I may have liaisoned with some municipal staff member to work on, to get. So all of that is, MFIPA does not apply to anything that I do. I'm also not a compellable witness. So that's really interesting. A lot of people have said to me, I'm taking you to court, you're going to have to answer. And I'm said, I've got immunity. I'm not a compellable witness at a hearing. So I can just say I have a duty of confidentiality. I can't be compelled to give testimony by a court, so it's not going to do you any good to bring me up in court. So, DiBiase, I want to mention this. This is, remember I told you that there was 4 judicial review applications brought in the province? This is the one that went to court and was actually decided. My friend Suzanne Craig is the Vaughan Integrity Commissioner, and she had butted heads with Michael DiBiase, the former regional council member, former mayor, and member of council. She got wind of a complaint, or a complaint was filed that staff were very unhappy with Mr. DiBiase. It's a very interesting decision. I won't go into all of the salacious details, but he ruled by a culture of fear. Staff were scared of him, and a number of people came forward. Suzanne Craig looked at the matter. She investigated the matter. And what she did is report that he, in fact, did contravene the code of conduct in many instances. Mr. DiBiase hired a very well-known lawyer, criminal lawyer, also administrative law lawyer, and he basically threw the book at Ms. Craig in court. I think there were 36 separate instances where he said she did wrong. She was wrong on this. She didn't do this appropriately. And when you see that, it's a shotgun approach, clearly. They don't have a good case, so what they're doing is just trying to throw at the wall, right? The divisional court looked at this. It was a very long decision, a little complex, a little hard to understand at points, unless you follow this stuff. And the court did not accede to a single argument that Mr. Manning brought on Mr. DiBiase's behalf. Completely sided with what the Integrity Commissioner did, and in fact said a number of things, and the last bullet cites them. The court said the Integrity Commissioner has an authority to decide when to investigate and when not to investigate. And just because she can investigate doesn't mean that she has to. That's partly going to, I think, your point, Madam Mayor, that I don't have to always investigate. There may be instances where it just doesn't justify the cost, the emotional toil on everybody that's involved. Look at the second one there. Integrity Commissioner can reformulate a complaint. So I get a complaint in, and I can say to the complainant, did you really mean to say this, or did you really mean to say that? And the court said, you can't expect a layperson to have to hire a lawyer to come in to file a really robust complaint. So the Integrity Commissioner has some authority to reformulate a complaint. I'll tell you, I've never done that, but I've often sent it back to a complainant and said, I'm about to dismiss this, but I'm going to give you one more shot at it. I'm not going to guide your hand, but you have to do something better than this. There's no reasonable or probable grounds. The way I see it, I'm just going to dismiss it. I have done that in a couple of instances. She can undertake a targeted email search on the municipal system. That's pretty evident, I thought, from what I was telling you before. She doesn't have to disclose the identity of witnesses. In this case, 32 people came forward, and believe me, the evidence was scathing. It was absolutely scathing against Mr. DiBiase. And the Integrity Commissioner said, no, I'm not going to tell you who said this. First of all, it should be pretty apparent when I tell you that witness X said this and witness Y said this. But I'm not going to identify her. And the court said that's absolutely appropriate because what's going to happen is going to be reprisal, and that is not right. So out of fear for the person's livelihood and their well-being, the court said, no, you don't have to identify witnesses. I've often said that I don't identify witnesses ever, except when you have to identify them. And sometimes you get into a he said, she said matter, right? So, Councillor Martin, someone brings a sexual harassment claim against you. So I'm reversing the role here, right? The normal role. You're going to say, well, I need to know. I need to know who did this. What did I do? Just, did I walk someone? Did I bump into them? Did I put my arm around them? I didn't, You have to know in some instances who it is, but not in every instance. I remember the one that I really argued was there was a social media post about someone, and the council member yelled at me from across, Harry will know who this is, yelled at me from across the parking lot, citing some Supreme Court of Canada case where, it was like someone going to jail and possibly, being imprisoned for life. And I didn't get it. And I said, it's on social media. You're identified as the person who posted it. Why do you need to know who the complainant is? And most people will say, we need to know because it's an abusive process, it's frivolous or vexation, these people are after me. Well, I'm the judge of that. I'm the person who looks at it. And sometimes, even though you may have someone who's, one of those people who are always filing these complaints, that doesn't mean that the time that they, the 10th time or the 8th time that they file it is not like a real complaint, something that justifies a review. Madam Mayor?
I understand that in that context within your investigation, but just to be clear, so some municipalities in the research that I've done, though, in terms of the actual complaint process, require disclosure. As our rules stand currently,
Yeah.
They are anonymous. In this case, one of the complainants, as an example, chose to disclose his identity, but that wasn't required. But some municipalities actually do require disclosure. Now, I can understand both sides of the coin where, okay, you want to encourage people to come forward. However, there's also the perspective of, I don't know, let's face it, you're not cheap. And we've got a financial crisis going on here in Norfolk. So when you have, a number of complaints coming forward, in some instances, the general taxpayer, I would say, would typically say it would be better to attach a name to it. That if you're going to go and spend taxpayer dollars on an investigation, you should be willing to put your name behind it. It's not like it's a whistleblower hotline where we're putting, lead in baby food or something. So I'm just wondering your perspective on that. That if we did redraft the code, and that would be, just to be clear, that would be something that we could do, that we require disclosure of.
Yeah, in answer to your question, yes, that's something that you could decide, Madam Mayor, and Council can say, no, in our municipality, we want to disclose. Now, I'll tell you what my view is on it. I think that's a bad thing. I think there's a chilling effect. I certainly see your perspective. I understand. I'm not trying to mitigate that. But there certainly is a chilling effect, and I think a lot of people might not want to do it, and they have justifiable claims. They just don't want their name to be put out there. And usually what I do, because I often get asked, I'd like to know who it is. I often will go, even in municipalities where it says that you don't have to disclose. Believe me, about half my municipalities do say that the identity will be disclosed. So it's about half and half. Some, on basically the same argument that you've put out, Madam Mayor. I think it's a bad idea. In most complaint processes, For instance, a bylaw enforcement officer gets a complaint. You don't go and disclose to the neighbor who went and complained. Why? It's commonsensical. The neighbor will be mad at his or her neighbor. So I think it's wrong, but there are instances where I think it is justified, and I would suggest to you that it should be in the Integrity Commissioner's responsibility whether to disclose or not. But I hear you, Madam Mayor, and I'm not trying to downplay what you're saying about that. I just think it's wrong.
Yeah, I agree in the instance with the neighbor against a bylaw officer, but again, we're talking about within the context of the Integrity Commissioner, just council, and, we are responsible to an elected constituents that elected us, and so, I think it's something that council has to take in perspective of what constituents view, and, certainly as these add up, I think we're already at our budget for what we spent this year. It is something that I think that is a fair, given that other municipalities do it, something to consider.
Yep. Councilor Michelle?
Thank you, Mr. Mascaron. Now that the mayor's asked that question, I'm always kind of just curious about, I do believe there is a principle, and I'm not sure if it's found in common law or statute law, where an accused person has the right to confront their accuser. Does that have any bearing in any of these possibilities?
Sure, it does, and it's a really good question. That was the argument that I was having in the parking lot at a municipality. It's like the accuser should always be able to make full defense to his accused. The court in DiBiase tackles that, and it quotes from a couple of sources, including the Supreme Court of Canada. It says procedural fairness is on a spectrum, and they put going to jail and being imprisoned for life over here, and they put a code of conduct violation over here, complete 180. They basically said, no, as long as the person knows the outline of what the case is against them, they don't have to know every minute detail. They don't have to see the complaint form. I recently had this in a municipality where it's supposed to be anonymized, and the complaint form has an affidavit, and then it has the second sheet, which says basically what the complaint is. So what we did is we gave the second sheet to the member, and his lawyer said, well, I need to see the front page. I want to make sure that it's a valid affidavit, that it was validly commissioned. I said, there's no need for that. I can tell you it is. I think what they were doing is basically questioning my authority to interpret that. It was a valid affidavit, so I didn't see the basis for turning that over, and I didn't. I said, no, it shows the name of the person. I could have whited it out clearly, but I didn't think that they needed to see that. And I think the DiBiase case will say I'm entitled to make that decision. So I see your point, and as per my outrageous example with Councillor Martin, clearly she should know if someone says, well, you did this, and she should know who it is. But other than those cases, I'm not sure that you need to know. And sometimes I'll give you another example of something that I often do. I often will dismiss, if you were to ask me, how often do you dismiss outright? About 40 to 60% of the time, complaints I just dismiss outright. And I don't tell the council member that they've had a complaint filed against them. And you might say, well, I'd like to know that. Why? Councilor Michelle, why would you want to know? I've dismissed it. I've decided there's no reasonable or probable grounds. It's frivolous. It's vexatious. Why do you need to know? It'll cause you a lot of turmoil. It'll probably get you angry. It'll get your blood boiling. And what good would that do? You'll probably ask me a lot of questions, and that'll be more time and cost. So I often don't tell members. Now, that's something that you could say, no, we'd like to know. Confidentially, we'd like to know who filed it. Madam Mayor?
So, Mr. Mascaron, is that your spectrum then, that in the case of sexual harassment is deemed to have a potential impact on a person's reputation, and therefore you would be entitled to know if it was a sexual harassment case, but you wouldn't in another case that would potentially impact?
No, that was just an example, Madam Mayor. I don't want to be beholden to that's my standard. I was just saying, if Councillor Martin didn't know who it was, I said, someone has come forward and said that you sexually harassed them. Well, what do I do? Well, you were speaking, I don't know, a little openly about something. She's probably thinking, I don't know, who the heck was I talking to, right? Yeah, I think you might need to know that. Now, that's just an example. I'm not saying that it swung way over there, but I've never had to do that. In fact, I've always withheld names in every investigation that I've done. But I often have gone to the complainant and said, "Do will you consent to your name being out there?" Sometimes they just say, "Yeah, sure, no problem." Sometimes they go to the media themselves, so the confidentiality shield is off.
I just think sometimes there's perhaps additional information that could be provided, that a history with an individual or so on in a hypothetical world. So I just wanted to be clear that the spectrum wasn't just sexual
No, it wasn't.
harassment versus not. Okay, thanks.
Enforcement, I report to council. That's a part of my duties. Periodic reports, I can't remember. I apologize if your code requires annual reports. But in annual reports, I have to anonymize and not disclose confidential information. But in reports on conduct and other types of reports, I can disclose, and it says there may disclose in the report, such matters as in the Integrity Commissioner's opinion are necessary for the purposes of the report. And that's for openness, transparency, and accountability. So that's the mechanism. Municipal duty, the reports have to be made available to the public. Now this is interesting because under MFIPA, this reverses MFIPA. If there's any allegation of wrongdoing in any kind of a report, on a council member, on a municipal staff member, it becomes personal information. That's what the Information and Privacy Commissioner of Ontario has ruled, and it's subject to not being disclosed. I had this interesting file several years ago where I investigated the mayor of a municipality, not as an integrity commissioner. I was just hired as an outside third-party investigator. The allegation was the mayor sat on the upper tier council by virtue of being the mayor, but he also sat on the lower tier. And he was entitled to expense certain expenses. And he attended the Roma conference and the AMO conference. And he expensed them fully to both municipalities. So he submitted the same bill, same invoice for travel, the same invoice for hotel, the same invoice for meals to both municipalities. In one instance, he said, "I'm attending as a regional councillor," and in the other one, he says, "I'm attending as the mayor." No one would have caught on to this except the person that he went with, who then blew the whistle. The two treasurers looked at it and they said, "It's the exact same expense reports." So he got double reimbursed, and I was asked to investigate. So I went in, investigated. So a public figure, an elected representative, using public funds, and then me being paid by public funds to do an investigation, and the MFIPA would say, and the Information Privacy Commissioner would say, it's personal information, you can't disclose it. That's really wrong. Fortunately, Section 16 says there's a compelling public interest exception. That doesn't apply here at all because it says all of the reports have to be public and they have to be made available. Most municipalities will post them on their website. Penalties, there's only 2 penalties that can be imposed, very clear by the Magdalen Ford decision. There's a reprimand or there's a suspension of the remuneration of the member for up to 90 days. And the 90-day suspension, it's actually been imposed way more than you'd actually think. I was quite surprised when I started to read this. Arbuckle from Town of Caledon just did his MPA master's paper on Integrity Commissioner reports, and I was quite surprised how many times the 90-day suspension of pay has been imposed. I haven't ever recommended it. I have recommended a much smaller penalty, but never a 90-day suspension of pay. The courts have also recognized that remedial or corrective measures may be imposed, and that was in the Magdalen Ford case. The divisional court said it's authorized. It recently had some notoriety with Justin Altman, the former mayor of the town of Witchert-Stouffville. He's the fellow who put up the CSI wall on his bathroom wall, the hit list of people he was going to terminate, who was going to fire, who was on his hit list. Toronto Star got a picture of it. Actually, it was Naved Noor who coined the phrase CSI wall. And the municipality was just fed up with him. And what they did, though, is in the guise of putting in remedial actions or measures, they actually wanted to penalize. I mean, the court saw through that, so he challenged council's remedial measures, and the court actually said, yeah, you can't do that. In order to have remedial measures, they actually have to be remedial or corrective in nature. They can't be sanctions, because there's only two sanctions, a reprimand or a suspension of pay. Council's role, when council receives a report, and if any contraventions are found, council has to consider it. You did so at the last council meeting. In appointing, though, an integrity commissioner, appointing me, what you've done is you've appointed someone, one, who's not local, so I don't know the politics here. I don't know things here. I'm an outsider in one sense. I'm completely impartial. I'm neutral. And I try to be objective in everything that I do. So when I come forward with a report, please bear that in mind. I don't have skin in the game. I've been appointed for 5 years. I can be removed for cause, but otherwise I'm here for this term of council. So I'm not trying to make decisions in order to get reappointed. I've always said if a council doesn't want a reappointment, that's fine, and some councils don't reappoint me because I'm doing my job. It's one of the hazards of my role as the integrity commissioner. I can live with it. All reporting for the purposes of accountability and transparency shall be done in an open meeting of council. And I would ask that you please don't cross-examine me when I'm giving my reports. And I rely on Toronto Integrity's Commissioner's annual report, where she says, it is plain to see that any value gained by assigning a neutral, independent, and expert officer to investigate misconduct on council's behalf is lost when council attempts to go behind the findings or challenge the lines of inquiry or analysis undertaken. That's you saying to me, I don't know that I like what you did here. I don't know that I'm going to inquire about it. My own personal view, I don't think that's appropriate. The member can ask me that, but I don't think it's appropriate for council to ask me that. I don't have skin in the game. I'm not here to sway political alliances, to do other things, and I'm not beholden to the residents as you are. I'm just here to do certain things under the accountability regime. So, look at the second paragraph there. This is not to say that members of council must agree with every report and finding. No, you shouldn't. You don't have to. Just because I say it doesn't make it so. However, she says in order to protect the integrity of the accountability framework and the role of the integrity commissioner, members should restrict their questioning and deliberations to the appropriate penalty or remedial action only. And I thank you, council, because that's exactly what you did when I was here. So I am thankful. I have been cross-examined. It's not pretty. And a lot of times I will rely on, I have a duty of confidentiality. I cannot tell you that. And it's like, well, why didn't you interview this person? I can't tell you that. It gets really frustrating. It's like a congressional investigation in the States where, someone, says, I can't tell you, I'm not going to tell you. So it becomes a little comical if you're sitting up there firing questions at me about why didn't I look at this person? Why didn't I do this? Why didn't I go investigate another 20 people or interrogate another 20 people? I'm not going to answer those questions, and I'm going to rely on the fact that I'm supposed to do everything under a cone of silence. So it gets really frustrating for both of us. So, conclusions, you've got a new era of accountability. All members now, local boards, as well as members of council are subject to the code of conduct. Integrity Commissioner has broad authorities to do all sorts of things. I've talked only about now the code of conduct, and I will in the second part, as my third bullet there will indicate, the MCIA, we have a role. Madam Mayor?
Sir, we haven't really touched on, we've spoken about sort of code of conduct within council chambers, and just, you used a couple hypotheticals, so I'm just going to use one now, but I don't know, let's say in a hypothetical world, Councillor Columbus was at a Tim Hortons disparaging his 3 female colleagues. Would that be in contravention of the code? I believe that we have a provision for conduct outside of council chambers.
Madam Mayor, yes, it doesn't just include anything that happens here or at the council chambers. So, for instance, Councillor Taylor, Saturday night, wants to send out some social media posts and all of a sudden decides to do something that I wouldn't have counseled them to do. He's a representative of the municipality. You read the municipal guide, the municipal councilor's guide by municipal affairs, it says there's 3 roles. There's a constituency role, there's a policy-making role, 4 roles, sorry, stewardship role, and a representative role. I've always said, you're an elected member of council, you're an elected member of council pretty much 24 hours.
So same thing, so using nicknames to disparage council members in public or so on, they would all fall within this?
I think so. Yeah, sure. Just because they're done outside the council chambers, I think it could
Okay.
be problematic.
And then one more question. I'm just wondering, you kind of skipped over at the beginning, and although the non-pecuniary interests aren't included within the code,
Yeah.
they do still apply, do they not, when we look at the broader conflict of interest rules with direct and indirect conflict of interest?
It clearly applies. The pecuniary interest applies for the Municipal Conflict of Interest Act, but your code doesn't actually cover non-pecuniary. So non-pecuniary would be, I don't know. I'm going to pick on Councillor Geisens. You have your best friend, not a family member, not your spouse, not your child, not your parent, but you're beholden to this person. You went to high school together, he was your best man at your wedding. Anyone would say he's got something in front of council. I don't know, like, do you have a personal interest? I would say you might. I'm not saying you do, because I don't know the facts, but you might. So a personal or private interest would be those sorts of things that aren't financial. Maybe Councilor Garza won't make money out of it, but he could benefit his friend, and that would be inappropriate. So that's what it's supposed to cover.
Okay. And just since we're on the conclusion, I'm just wondering, I know we have a couple council members with sort of family members within Norfolk County. I'm just wondering if you could touch on how that would work with immediate family members that do work for the county.
There's you certainly can't benefit your family members. So let's say someone has a niece that's working at the municipality, and the niece is up for, let's say, a statutory appointment. She wants Mr. Gazelle's job. She wants to be the clerk. That member, I think, would have a problem convincing me that they wouldn't have a personal interest in that person, even though it may not be financial, right? But it would only relate to that. The person, otherwise you'd be saying that any of your family members couldn't be employed by the municipality. And I don't think that's the law at all in Ontario. And I'll show you a slide coming up on the MCIA. So you have to be careful that those particular interests don't conflict with any decisions that you may have to make. But I don't think there's anything inappropriate with someone having a family member who works for the municipality.
But if somebody were to have information from a family member that could be used to ensure that somebody acquired a job, that might not be a conflict of interest, but it could be potentially a breach of the code of conduct. I believe we have a rule that states that you can't use information to ensure that, somebody receives employment.
Sure. So the member wouldn't, it would be wrong for the member to go and ask their spouse who works in the planning department, who are you planning to hire as this person, or the treasurer, who are you going to hire as the deputy? I think that wouldn't be right, and it would probably be wrong from the spouse's point of view, the family member's point of view, to disclose that information if it's confidential. So, but does it? Yeah, it could possibly fall within here. Yeah.
And then it just, I guess, so would a non-pecuniary interest, would that be something, or sorry, let me roll that back. A pecuniary interest, that could be something like, I don't know, let's say a zoning change, if a zoning change was approved by council and somebody's land was devalued as a result of their neighbor's change in zoning, that could potentially be deemed a pecuniary interest if it was a family member. Potentially.
Certain family members, yes. And I'll get to that, and I'll give you the example in just a moment. Yes. So let's say you're Let's say your brother has a property and right next to it is supposed to be a waste disposal, be rezoned for a waste disposal facility. I think the brother would say, I don't want it to be that way, and I think the council member would have some difficulty. Would it fall under the MCIA? Probably not, and I'll explain that why. And your code doesn't cover it. Because it doesn't cover non-pecuniary interests. So that's the lacuna there, and I think it should be corrected.
That our code should be corrected to
Yeah.
include that. I agree. Thank you.
Before I leave this topic, were there any other questions on the municipal accountability framework before I move on to the MCIA? It's all clear? Great. Okay. I will go, and I hope to be, I don't know, about 30, 40 minutes on this, but please, again, if you have questions. The Municipal Conflict of Interest Act, the MCIA, the granddaddy of all accountability statutes, been in place since 1972, but it goes way, way back. Some people have traced it back to the Baldwin Act in 1849. Legislation, lots of judicial consideration for such a small statute, lots of consideration. Applies to members. It doesn't apply to staff, okay? Only applies to elected and appointed members. Mullen Fisher, I'll just leave this for you. The purpose, it's of course to preclude members of council from making decisions on things that they would have a financial interest in. And before you take your seat, you've sworn a declaration that you will comply with the statute. So number 3 says that you will disclose any pecuniary interest, direct or indirect. So it's a personal obligation that you have. I would encourage you, please read the statute. And if you're only going to read 3 sections of it, read 5, 5.1, and 5.2. And even if you don't read it, I'm going to tell you about them right now. Here's the principles, something new. Justice Cunningham recommended them from the Mississauga Judicial Inquiry. They were put in place. The one I want to point to, the first 3 are pretty commonsensical. Look at number 4. There is a benefit to municipalities when members have a broad range of knowledge and continue to be active in their own communities, whether in business, in the practice of a profession, in community associations and otherwise. I always used to get, they're a part of a cottage association. They shouldn't be a member of council. They shouldn't do this. Or they're a contractor. They shouldn't be on the committee of adjustment because no. This clearly says there's a benefit to you. Councilor Martin, you're a local business owner, right? There's a real benefit to you being on council. You have an interest and you see it from a different perspective. I didn't mean to pick on you. I'm sure other people have business here. I just don't know what everyone else's business is. But I like number 4. I think it gives some clarity to some of the decisions. And I often have pointed to it. And I said, no, there's nothing inherently wrong with a member having interest in the community and being part of a group or however, how they deal with it is important. So, common meaning, and this is where the public goes a little crazy because they don't understand it. The common meaning is what you think. You have a personal or private interest that conflicts with your official duties. That's what everyone thinks it is. It's not that. In fact, I'm speaking at AMCTO. Andy, I hope to see you there, at their annual conference. And my topic is 10 things that will surprise you about the Municipal Conflict of Interest Act. One of them is the term conflict of interest is only used once in the whole statute. It really means you have a direct, indirect, or deemed pecuniary interest. And there's no definition of direct or indirect. So what is a pecuniary interest? It's a financial, economic interest. That's what it is. And it can, as I said, can be direct, indirect, or deemed. It can be positive or negative in nature. Positive means that you can gain from something that's in front of council, or negative is Madam Mayor's example there where it could devalue your property, so you have a financial interest in it. And the matter arises in something that's before council or before staff. So what's a direct interest? That's the easy one. It's when you have the interest, you personally have the interest. And it can relate to a potential interest. Now, the Act is not interested in remote or speculative financial interest. So the one I always get at the beginning of every council term is, I'm a real estate broker in the municipality. Does that mean I have to always always declare a pecuniary interest anytime there's a rezoning, an official plan amendment, a site plan approval, a subdivision approval? And my answer is not necessarily. It all depends on what may happen, but you may have a financial interest. So a potential interest may be an actual interest. An indirect interest is one, it's under two, where you might have some sort of corporate involvement. So you're a corporation, you're a director, you're a shareholder, you have a controlling interest. You may have some sort of corporate interest in the matter. Or you're partners. You may be in a partnership. So for instance, if I was a member of council and my partners were coming in front of the municipality seeking to do all the municipality's legal work, I would have a problem because I'm a partner of that entity. If one of your employers is coming in front of council for business to get an approval of an RFP, a tender, or a license, you would have a problem with that. You can't do it because their interest is your interest, subject to one caveat. Yes, Councillor Hoffman?
Sorry. So it is a small community, so I mean, for the most part, yes, people would know that Councillor Martin does have, her business, and that's not a big surprise or anything. What if someone has a business that they haven't disclosed to anybody?
Yep.
Where does that come in?
Well, there's no obligation on members of council to go and disclose,
Okay.
but you have to still be guided. So if you know you have a business,
Right.
maybe a mail order business or something that's coming before council, and I can't think of a good example, but you have some business that you're running or operating, and it's coming before, and you could benefit. It's your personal obligation to make that disclosure. So you have to decide. Now, someone else may not know about it.
Okay.
Right? You may not have an open business that's a retail business that's up on, Main Street, but it's still your obligation.
Okay.
Okay?
All right.
The one that's really problematic is, I think, the fourth bullet. You're a member of a body. And body is not a defined term. In the Orangeville and Dufferin case, the court said it has to be given its broadest possible connotation, but it's been subject to some conflicting case law. In one case, it said, no, it deals with just strictly unincorporated bodies. Justice Healing, in a decision last year, said, why? It says body. Why would it exclude a corporated body? It doesn't make any sense. So there's conflicting rulings on that. I would say just be careful. A body could be the Rotary Club, could be a cottage association, could be, I don't know, something that's going on in the municipality. Body is a sort of a loose term, so just be careful, because the Ontario Court of Appeal said it has to be given its broadest possible connotation. That's problematic. I think it's really hard for you to make those decisions. So that's why I'm here to help on things like that. Yeah, Madam Mayor?
Thanks, sir. I just wanted to touch on Councillor Huffman's point. So just to be clear, so somebody has a business, they are under no obligation to disclose if it has nothing to do with Norfolk County.
I don't think you actually have any obligation to disclose otherwise. But again, it's your obligation. So if your business that you've told no one about, all of a sudden something that you do here could impact your financial standing, then there's a problem. How someone would find out about it, I don't know, but that's not your problem. But it's your obligation. You have to abide by what that says. But there's nothing that says you have to disclose what your businesses are.
Thank you.
Deemed interest. This is the one I think we've talked a little bit about. The interest of a spouse, that's common law, same sex. Your child, minor, age of majority, parent, even someone who stands in the standing of a parent, like a grandparent. I recently gave an opinion to a mayor of a municipality. He's a grandparent, but through some tragic family circumstances, he's raised his grandchild really as his own. And I said, he's your child. You're standing in locus parenti to him. So those interests, those financial interests of those people, if you know about them, are deemed to be your interest. Okay? So if you have a spouse, a child, or a parent, that's what you have to worry about. Their financial interest might be your financial interest. You have to know it. So if you don't know it, well, then it becomes a matter of proof. Did you not know or did know? Notice that it says a direct or indirect interest. That's curious. Again, one of my 10 things that you should or don't know about the Municipal Conflict of Interest Act. If you read Section 2, indirect, it's very bizarre, the language there. And I'm not really sure it actually talks about an indirect interest of a spouse, child, or parent. Yes?
Sometimes, Mr. Mascaron, can it go beyond a spouse, child, or parent?
Not this act, no.
Okay, but
Yeah.
other, in a different way.
But you could, in your own code of conduct, cover those familial relationships. And you'll often see that they'll talk about close relative, and then they'll define it as being sibling, aunt, nephew, niece.
Niece.
You know, yeah.
Okay, thank you.
So, what are your duties? And I'll run this through twice, okay? If you have a matter in front of council or a committee or where you're a member, whether it's a police service board, a library board, you have to, if the matter is a potential pecuniary interest or a pecuniary interest, matter of pecuniary interest, you have to disclose the interest in the general nature. So you have to actually state it at the beginning. Your own procedural bylaw does say that, that you have to do. That's probably one of the first things on the agenda, I think, that, Madam Mayor, you ask, or anyone who's in the chair asked, does anyone have any declarations of pecuniary interest? Then you can't take part in any discussion, you can't vote on it, and you can't attempt to influence the voting in any way before, during, or after. Okay? Now, people say, how can you vote? The votes happened. How can you, because it's in committee, it may still be going to council, so you can't go and talk to people. If you declared, and there's a recent case on this, Biffis and Sainsbury up in Newt-Tecumseh, where the member declared the pecuniaries, and then just before the council meeting said, hey guys, I hope you're going to support me on this. The court said it was a technical breach. Let the council member off. You can't, this is the Hazel McCallion amendment, okay? You can't influence the staff. This is brand new. Please be aware of it. It used to be only matters before council or committee. Now, as you probably know, a lot of things happen before you get to council, right? Before you get to committee. You can't go and talk to staff about it. So this expands the MCIA quite broadly. You can't attempt to use the influence of your office to get staff to do something before it's gotten there if you have a pecuniary interest. So the reason I say this is the Hazel McCallion Amendment is because if you remember the Mississauga judicial inquiry that Mississauga asked that they look at Hazel McCallion, she said, I declared a pecuniary interest every time my son's matter came before council and committee. And Justice Cunningham said, that's absolutely right, you did. However, behind the scenes, you were meeting with everybody and you were trying to get them to move forward with the hotel and convention center complex, and that was inappropriate because your son had an equity interest in world-class developments. So, again, please be aware of this. This is a real expansion. Madam Mayor?
This, sir, would also apply equally to staff members, correct? If they had a conflict of interest?
No.
No, okay.
This, just to be clear, and I went through it quickly, right at the beginning, it applies to members of a local board, members of council. It doesn't apply to staff. Does not apply to staff, only elected or appointed officials. The obligation is personal to the member. In Cooper-Wianco, a case out of Georgian Bay, the decision to exercise the obligations set out in Section 5 are characterized as a matter of personal judgment for each member of council. So the member can't rely on the clerk, can't go to the chief administrative officer. I know, Mr. Slang, you've probably been asked many times, do I have a conflict of interest? It's not for you to say. It's not for the clerk to say. It's not for the solicitor to say. You can come and ask me, and I can give you some advice on that. But you can't ask anyone else. It's your own personal obligation. Remember, you swore a declaration that you would do so. There are a number of exceptions. There are 11 exceptions. The first 9 in their book, George Rusty and Rick O'Connor say they're commonsensical and straightforward, and they're self-explanatory. And yet, I spent half a day in court arguing number I there, an allowance, remuneration, salary, or benefit that the member may be entitled to by virtue of office. So I said to the court, Your Honor, there are no cases on this. Why? Because the 2 authorities who have written on this say it's commonsensical and self-explanatory. And so the Justice Wood said, okay, Mr. Mascaron, Tell me about it now. And so we spent half a day arguing. The two that you need to be aware of are J and K. Those are two general exceptions, and you'll see them apply often. So let me run through them. There's an exception if you have an interest that you've shared with other people, that you share it with other people generally. It says an interest in common with electors generally. But let me tell you that generally doesn't mean municipal-wide. Because why? There's a definition of interest in common, and it means the area of jurisdiction that the matter refers to. So let's say, and I argued this in court, I was representing the mayor of Belleville. He had a property that he was a director of, a corporate director of a company that owned a property on a street that was going to be improved. The street was a large swath of an area. There was, I think, 158 properties. And I said, that definition applies. Clearly it applies because the area of jurisdiction is not over the whole municipality. It's only over that one area. The court said, okay, I buy that. However, his interest is a little different than everyone else's. So the question is the difference a difference in nature and type, or is it a difference in degree? If it's the latter, you're okay. You fall within the exception. But if it's a difference in nature, then you don't fall within the exception, okay? And it's a general exception that most members will try to argue if they ever get caught up in it. They'll say, well, I have the same interest as anyone else, and the court will dig in and say, maybe not. The other one is the remote or insignificant interest. And the test from that is from a well-known case, Whiteley, that came hot on the heels of another case that's often referred to, Jaffine and Mortson. That's the case where the mayor of East Gwillimbury had a property that was going to be expropriated by the province for the 404 extension. And he said, we should just move this ahead. And the court said, that's kind of problematical because that could have been millions of dollars of the province expropriating a property that was farmland. But the court didn't come up with a really good test, and I think, quite honestly, I think the decision was a bit in error. And 6 months later, Whiteley and Schnur came up, and the test is, would a reasonable elector, so now they're imposing a reasonableness test, being apprised of all of the circumstances, and there's been like 4 recent cases that have said you have to think of all the circumstances, not just one. Don't just cherry pick one of things. Would the elector be more likely than not to regard the interest of the council member as likely to influence the member's decision? So remoteness. The remoteness relates to the immediacy or potential of financial or economic interest. So the Darcy and Minnow case says the fact that the dollar amount at stake, in that case it was $50, doesn't matter. It was still a financial interest. Significance, Mayor Ford, former Mayor Ford, said in front of Justice Hacklin, he said it on the stand, what does $3,150 mean to me? I'm a rich man, I'm worth millions. So Justice Hacklin said back, well, first of all, that would mean a lot to any person in Ontario, respect for the people. But what about the significance of it? This was important to you. You wanted to talk about it, and that was inappropriate. So he didn't fit within the exception. Now, this is really going to complicate things. This is a terrible decision. It's a terrible decision from the Ontario Court of Appeal. Look at the style of cause, Ferry versus Ontario AG. And you'll say, hold on, this is a municipal conflict of interest case. How did it become a municipal conflict of interest case if the Ontario Attorney General is involved? It's because Mr. Ferry, who is a council member in the city of Vaughan, wasn't sure if he had a pecuniary interest or not. And here are the interesting facts. His son, really nice guy, is a municipal lawyer in Toronto. He works for a well-known firm, a firm that I've often gone up against, Loopster Nixon. Loopster Nixon is a great firm, and they had a file. His son had a file on the official plan amendment in the city of Vaughan. It was the first official plan amendment in many years in Vaughan, and Mr. Ferry said, my son is acting on this. Do I have a pecuniary interest or not? So he went to court. He didn't go to court. He wasn't challenged. He went to court to say, do I have a financial interest here? Do I have a pecuniary interest? The judge at first instance, I think, made the right decision. He said, hold on, your son is an employee of Loopster-Nixon. Loopster-Nixon has a file in front of the city of Vaughan, so therefore your son has a financial interest, indirect. You are deemed to have that financial interest, therefore you can't vote. He went to the Court of Appeal, and look what the court says. The analysis of whether a councillor's pecuniary interest is too remote or insignificant to be reasonably regarded as likely to influence the councillor cannot be premised on the notion that unless proven otherwise, the councillor is fixed with the same level of proximity and significance as his child. So, a deemed interest is a deemed interest is a deemed interest, except when it's not a deemed interest. I think this is a terrible decision. And I've said so. It's the Ontario Court of Appeal. I remember I went and argued this, and I brought it forward, and the judge was astute enough to say, how did this get to the Court of Appeal? And I'll tell you why he asked that question in just a moment. So this makes it really complicated. Again, you have a personal obligation to abide by this, but the rules are really complex. Partial exemption, you are entitled to speak to a code of conduct matter if it's, let's say that there's a matter in front of you and there is either a recommendation or an imposition of a remuneration, a suspension of remuneration of pay, you're entitled to speak to it. You can't vote on it, but you can speak to it. That's the Rob Ford Amendment. I think I spoke about it last week when I was here. A duty of disclosure arises when the matter comes before council, or the matter is, of course, before staff. You have to disclose the interest, and you have to disclose the general nature. Now you also have to provide a written statement. So if you disclose it, you have to provide a written statement. Let me give you a little bit of helpful advice here. If you know you're going to have a pecuniary interest in the matter, complete the statement before you declare it. And then when you go to declare it, say exactly what's in the statement. Because what's going to happen, mark my words, someone's going to say something different in their declaration, and then they're going to hand in a different statement. And some astute resident will pick that out, and they're going to say, I don't get it. They're discordant. They don't work together, and there's going to be a challenge. You don't want that. Mr. Grisal, apart from all of his other duties, also has to now create a registry. So he has to maintain a registry. This is great for people who try to go and find out whether someone did disclose or didn't disclose, because otherwise it would be hard to look through the minutes. Because, as you know, things happen during a council meeting. You don't actually always know at the beginning of the council meeting whether you have a pecuniary interest. Sometimes you only find out later when there's an amendment to the matter. Bill 68, of course, now says that you can come to me for advice, and a couple of you already have, and I've provided written advice to you. Again, it has to be in writing. So let me go through the requirements just one more time, just to highlight them. Disclosure, you have to disclose, declare the pecuniary interest at the beginning. You can't participate. You can't take part in the discussion. You can't vote on a matter. You can't attempt to influence it in any way before, during, or after the meeting, okay? Ontario's interesting. I've been giving some advice out of province. I haven't done this in my career. In the last couple of years, I've been asked to give advice in other jurisdictions. Almost every other jurisdiction in Canada requires a member, if they declare pecuniary interest, to leave the meeting. That's not the law here in Ontario. You only have to leave a closed meeting. However, it's a good practice to do so, because even a roll of the eyes, a kind of a flippant look or something, might say to someone, oh, that person is signaling. And there's been a case on that where a school board trustee was walking out of the room and either gave a thumbs up or thumbs down. And that was taken as an attempt to influence. And there was like 3 days of cross-examination on it. It's crazy. File the written statement, file it with Mr. Grisel, and you can't influence employees. So that's outside of the council and committee meeting setting. There's a record of disclosure. I won't go through that very much. Let's say a number of you have a really controversial matter, and you all have there's 9 members of council. 7 of you can declare a pecuniary interest and leave it to up to 2 members to vote. There's a reset of the quorum rules if people declare pecuniary interest. And this happens. City of London was having a problem, Kitchener-Waterloo with the LRT, up in Muskoka Lakes several years ago. I think out of 9 people, I think 7 declared pecuniary interest. Applicants, it used to be that only an elector could take you to court. They've expanded the authority of this. It used to be really hard for someone to challenge you, right? They would have to actually bring a court application, hire a lawyer, and people would always say to me, how much will it cost? And I'll say it all depends on what the defense is. It could be very expensive. Now, an MCIA application can be brought by an elector. It has to be an elector in this municipality, not just an elector in any municipality. That's different from the MEA, right? The Municipal Elections Act, where anyone can go do a compliance audit, because that's coming up, right? A person demonstrably acting in the public interest. The original version used to say any person, then they changed it to the person demonstrably acting in the public interest. So let me ask you this. Can council bring an application against one of its own members? What's the definition of person in the Municipal Act? It says it includes a municipal corporation. Who runs the municipal corporation? The council. A council now can bring an application. This wasn't the case. I was in court where the mayor had brought an application against the member of council, and the court said it was an extraordinary action for the mayor to bring an MCIA application against one of his own members, and actually awarded $25,000 against the mayor for doing so. So now I think the law's changed. Yes, Madam Mayor?
What about a former member of council?
I'm sorry?
So I know that the code of conduct you mentioned doesn't apply in our case, that we haven't modified it to apply to former members, or sorry, that it did, it mentions it, but that it would be unenforceable.
Yeah.
But in the case of MIFO, would that, or within the municipal conflict of interest, would that, could that apply to former council members?
Yes, yeah, I'm sorry, very good point. I don't have it in my slide. You're right. It applies to former members, and the reason being, people who've been defeated will often want to come back, and if they've done something wrong, the case law says that you can possibly challenge someone who's a former member and bring an application.
So if this council, through our work, learned of some potential conflict that existed previously that was not disclosed, would that be grounds to bring something forward then?
Well, you could certainly, I think you could ask me to investigate. I'm just trying to think if then my jurisdiction as integrity commissioner would allow me to go back. The act says that you can bring it to court. I'm just not sure that you can ask the integrity commissioner. I'll have to get back to you on that.
That'd be great.
I actually don't know, and I've never been asked that question. You've stumped me.
Okay, thanks.
Application period. The application period continues to be 6 weeks from the date that the person had a reasonable subjective belief that there was an infraction, contravention. Okay, and the onus is on the applicant to say that they've satisfied the 6 week period. So you'll see affidavits that say, "I only learned about this 6 weeks ago." There's an ultimate 6-year limitation period. So even though you may have learned about it 6 weeks ago, or only within the last 6 weeks, if it happened 6 years ago, then you're out of time, right? More than 6 years ago, you're out of time. There's an election blackout period. You can't bring this during the nomination period, so whatever date that is, you can't bring it from that to the voting day, and you'll often see that a lot of applications were often brought during an election year to smear some candidates and some officials. Inquiry by integrity commissioner, yes, I can conduct an inquiry. An applicant, an elector, or a person demonstrably acting can come and ask me. I have to complete the inquiry within 180 days. They put a finite period. Upon completion, if I find that there are reasonable and probable grounds to suspect that there is a contravention, I may actually bring an application to the court. So that's something new that, again, I thought that this was where people were going to come forward, and I think people will come forward because in many cases the contravention of a code of conduct is a pretty minimal penalty. Here, you'll see in a moment, the penalties could be quite severe, so here they are. The two in red are new ones, and they look familiar, right? They're from the code of conduct, but you can be removed from office for contravention of the Municipal Conflict of Interest Act. You can be disqualified for up to 7 years, and that's when sometimes people bring an MCI application against the former council member, And then they could be disqualified for 7 years, which means that they couldn't run again the next time. And restitution of any personal or financial gain. By the way, those aren't penalties that I can impose or that council can impose. Only a judge can impose those. And in exercising their discretion, the judge can consider, did the member take reasonable precautions to prevent the contravention? Was it committed through inadvertence or an error in good faith, which were the two saving provisions? But look at B. Remember I talked about it before, and I think it should find a place in your code. Did the member disclose the pecuniary interest, all relevant facts known to him or her to the Integrity Commissioner in a request for advice, get the advice in writing, and then follow it? If they did, the judge will let you off. The judge will say you couldn't have done anything more than that. Appeals, this is where it gets interesting. There's only one appeal, and the appeal is only if there's an order made against the member. So if someone brings an application against you and you're successful at first instance, they don't have an opportunity to do another appeal. They can't go to the Ontario Court of Appeal. They can't go to the Divisional Court. However, if there's an order made, again, one of the orders is the ones that I showed you before, a reprimand, suspension of pay, you can appeal to the Divisional Court. But the applicant can't. The applicant only has one shot. You have an opportunity to appeal. And the Divisional Court is the final court. You can't go to the Ontario Court of Appeal. In most cases in the province, you can go to the Ontario Court of Appeal. You can't in this. Almost finished. So what happens if there's a 5-4 vote, but one member ought not to have voted because they had a pecuniary interest and it's determined that they did? It won't invalidate the proceedings. So the decision isn't void, it's voidable. That means the council has the discretion to say it's a void decision, and you can only do so within 2 years, but it doesn't make the decision absolutely void because of that. And my conclusions, each conflict of interest case must largely stand on its own facts. That's how come you have so many cases on this, because they all turn on little nuanced facts. And again, in Cooper and Wyanko, what constitutes a sufficient pecuniary interest to trigger Section 5 will not necessarily be demarcated by a bright line. That's why I think I told a couple of you at the beginning of the term, you can't just ask me for an opinion that will hold you in good stead for the whole term, because it all depends on the matter that's before council or before the municipality at a particular time. So I'll give you an example. Councillor Huffman, you may have your spouse who has a matter and you declare pecuniary interest. But then your spouse is no longer employed with that entity or is no longer a partner with that firm. The next time you don't declare pecuniary interest. It looks odd to the general public, but you wouldn't necessarily have to do so because the thing will have disappeared because he doesn't have that indirectness anymore. So that's an instance where factual circumstances change. So finally, conclusions, conflict of interest isn't what the public generally thinks it is. It only talks about pecuniary financial interest. There's a positive personal obligation on you to declare an interest, to not deal with staff. There's a large number of exceptions under Section 4. The first 9 are very specific and pretty self-explanatory. The last 2 are very general, and that's where most of the case law is. Significant sanctions, you could lose your office. Doesn't happen very often, but it happened almost famously in the Magner and Ford case, where Justice Hackland said, you breached the Municipal Conflict of Interest Act. You didn't do it because it was inadvertent, and you didn't do it because you made an error in judgment. Therefore, I have to remove you. It's now not automatic anymore. It's at the judge's discretion. So if you come and ask me, and I give you a ruling, I give you advice on it, and you follow that advice, and the advice says you're good to go, then you can rely on that, and the judge will probably treat that as immunizing you. Madam Mayor, that's it.
Councillor Columbus has a question for you.
Yeah, thank you, Madam Mayor. I've got a few here that I wanted to run by Mr. Mascarin that might help other councillors that I've seen occur around the table here over the years. And one is, if you're a member of a organization like a Lions Club, and they're asking for a waiver of a fee to rent an arena for a function, is that considered a conflict? Should the councillor report a conflict of interest?
The Lions Club in that case would be a body. The interest of the body would be your interest if you're a member, of that organization. Therefore, you have an indirect pecuniary interest, and you should declare it.
And if you were a member of the Port Dover Lions Club, but it's the Langton Lions Club that wants, should you still declare conflict, even though you're...
So it's another entity that you're not a member of.
Right.
Okay. That's interesting. If it would conflict with your membership's, your body's interest, let's say there's only a finite number. Council will only give one grant. That'd be a problem because you'd rather get it for yours, so you might vote down the other one. So again, very fact specific. So I can't say you wouldn't have one. You might have one. I've given you an example that may not even be true in life, but that's an example where you may have a problem.
Okay, the next one is, let's say you received a healthy campaign donation, and coming later, someone coming to make an application for a zoning amendment or something.
Yeah.
How do you handle that?
And the healthy campaign donation, would it have been less than $1,200?
It'd probably be in that order, yeah. I'm saying any campaign donation,
Okay.
$50.
Okay, any, but it wouldn't be more than $1,200, which is the maximum allowable contribution limit. Okay. No, you wouldn't have a problem. As long as you've put it in your campaign financial statements, then you're okay. There's 2 cases out of BC that speak to it. I actually have an actual complaint right now saying not this mayor, the mayor, another municipality, is clearly siding with this person because he made a donation. The donation was actually $750. No, there's no problem. The law entitles someone to, allows someone to make a campaign donation, you to receive it up to the maximum limit as long as you disclose it. So you don't have, there's no problem with you speaking on their behalf, unless there's some other bias that I don't know about.
My next one is a counselor owns a downtown business, and there's a large superstore opening up on the Queensway that's going to sell similar items.
Mhm.
Should that counselor declare conflict of interest?
Would there be a financial impact? Sorry, just let me ask, would there be a financial impact? I think most people would say maybe, probably. So again, I said earlier, the act doesn't look at speculative interest. So you'd have to draw a little bit. So let's say there's doing the exact same thing, but let's say it's a little coffee shop and you've got a Starbucks that's opening across the street. I think that would be a problem. I would say, yeah, there might be an impact on finances, just commonsensically.
My last one, Madam Mayor. Say you're an insurance agent and you have one of your customers, say you've got 2,000 customers purchasing insurance from you. Should that insurance agent report a conflict of interest and not vote on the item?
So you're the agent?
Right.
You're the agent, and you're the person who is in front of council. Your client is in front of council.
He pays a premium, and I get a commission off of it.
Yeah, I think that might be a bit of a problem.
Thank you. These are things that over the years you see come around the table.
Yeah.
Okay, well, thank you very much for coming.
Thank you very much for having me. Again, if you have any follow-up questions, you can ask me for written advice, but I also appreciate that there's a cost to it, so I've always tried to do it proactively, quickly, and efficiently. And I know I've given a couple of members maybe a little bit more because you're new members, and I thought that the guidance would have been helpful. But thank you very much for having me.
Thank you. I know, just to the clerk, that there was some concerns from the community. I had a few phone calls in terms of the timing with last week and this week. Hopefully, maybe in the future, we could combine the visits to save on Mr. Mascaren's travel time coming back and forth. So let's take maybe, let's say, 5-minute quick break here, and then we'll begin with the public meeting. Okay, welcome everybody. I think, unfortunately, I'm being told that we have too many people in this room right now for our fire code. So we've opened up committee rooms A and B, and there are some television screens that are on there that are streaming directly from council chambers. And so when you are ready, we would be able to, if you wanted to speak, bring you back into the room at that time. So if we can maybe get a group to head over to committee rooms A and B. No, well, we'll bring you once everybody goes through, and you can certainly come back in and present when it's time to do so. But you'll be able to hear it. It's all streamed over there.
Yeah, both rooms can fit about 20 or 30 people, so we should be able to get about 50 people. If you're in the you're in the aisles, we want to keep them free for people to walk through, so please try to filter back. Yeah, it's right through there.
The other point I just want to make is that we have about 4 other public hearings to go first. They shouldn't take long. The challenge is if the wetlands were to go too late, and then we risk not hearing the others. So we're going to do those. They're on the agenda first. We're going to do those first. They won't take long, and then we'll hit the wetlands. Okay, so I guess we can begin. We're going to skip over on our agenda down to the public hearings that were slated to commence at 5 o'clock. I would now like to officially open the public meetings held under the Municipal Act and Planning Act, and a reminder to those residents that desire to address council tonight to write your full name and address when you come forward to the podium. Those speaking on planning matters, please be advised that to preserve your right to appeal to the local planning appeals tribunal, you are required to make comments or provide written submissions prior to the passage of a bylaw. The first matter before us is DCS 19-54. That's regarding a zoning bylaw application that has been received to allow a garden suite as a temporary use for a period of 11 years. Peter and Ann Bergen have put forth the application affecting the lands described as 2716 Highway 3 in Delhi. I now open the public meeting on staff report DCS 19-54, and Ms. Van Dalen, if you could please present your... Oh, and Neil's going to... Okay, if you could please present your report, sir.
Thank you. This is an application for a garden suite. The subject lands are 3.14 acres in size and front onto the south side of Highway 3. They contain a single detached dwelling, a detached garage, and an existing shed. The lands are zoned to agriculture with a small strip of hazard lands on the west portion of the lot and designated agriculture and hazard land in the official plan. This application is to permit a new garden suite for an initial period of 11 years. At the end of 11 years, an extension may be applied for if the need is still required. The applicants have demonstrated need, and the application conforms to the official plan and the zoning bylaw. Staff support this application and recommend that it be approved.
Thank you. Any questions of council members? Okay. Are the applicants Peter and Ann Bergen or an agent here on their behalf? Okay. Are there any members of the public that wish to speak in favor of the application? Are there any members of the public that wish to speak in general or against the application? Okay. Again, any question of council? All right, in that case, if I could have a verbal motion to close the public meeting. Councillor Martin, seconded by Councillor Taylor. All those in favor? And would somebody like to move the staff recommendation or propose an alternative?
Thank you, Mayor Chop, and through you, I'd like to move the staff recommendation as printed on page 137 of our agenda.
Okay, thank you, Counselor Rabbits. And is there a seconder? Counselor Taylor. Any discussion? All those in favor? And that's carried. Okay, next is DCS 19-15. That's regarding an application that's been received to amend the Norfolk County official plan and zoning bylaws to permit residential as the sole use on the ground level of the subject lands. The purpose of the application is to bring the non-conforming use into conformity, which has existed for many years on the site. Michael and Tracy Bancroft and Agent Civic Planning Solutions have put forth the application affecting the lands described as 40 and 38 Alice Street. I now open the public meeting on staff report DCS 19-15, or 57, sorry, and Ms. Van Dalen, is that you this time? If you could please present the report.
Yes, Mayor Chop, thank you very much. Good evening to council and staff, members of the public. This is an official plan amendment and zoning bylaw amendment for a property in Waterford located on Alice Street. The application is to consider an amendment to both the official plan and the zoning bylaw to recognize an apartment, a residential unit on the main floor. The policies typically require street frontages to have commercial components when you're in the downtown areas. And this application is to recognize an existing situation where a unit has been put into the building, and this amendment will be to recognize and legalize that situation. There was no concerns raised regarding the amendments from the departments and agencies, and there was no comments received from the members of the public, and therefore staff are recommending support of the application, and I'm happy to answer any questions you might have. Thank you.
Thank you. Questions from councilors? Councilor Van Passen.
Thank you, Madam Mayor. I do have one question. On page 144 of our agenda, the comments from the building and bylaw. If this is an existing situation, why do we need a building permit and a change of use permit?
Through you, Madam Chair, the unit was constructed illegally. It was placed in there without any permits being completed. The property changed ownership, it was brought to their attention that when they purchased the building that this unit was non-complying with respect to the policies that are in play. So what they're doing is seeking to recognize the situation. So as part of that, they do need to ensure that that residential unit is in compliance with the Ontario Building Code.
Thank you. Any further questions, councilors? Okay, are the applicants Michael and Tracy Bancroft or an agent from Civic Planning Solutions? Mr. Rowe.
On behalf of the applicants, the brief history on this is that the conversion was done several property owners prior to the current owner. However, when the current owner looked at some refinancing, a zoning verification was required, and it was found that this unit hadn't legally been established. So based on the title insurance and what have you, we brought forward an application to resolve the situation.
Thank you, sir. Any questions of councilors? Councilor Rabbits.
Thank you, Mayor Chop, and through you to our deputation. I just have one question. I wanted you to describe in some detail, briefly, the frontage. What are we looking at? Are we looking directly into someone's bedroom window? Is it a restroom? Is it their kitchen? Just maybe provide us a little bit of context. I realize it's a multi-residential apartment complex, but having not been to the site, I apologize. I was wondering what the frontage is actually appearing like in terms of the aesthetic.
The frontage does have windows onto the street. However, they do have curtains over them. I don't think there's a real lack of privacy from within the unit. It's a one-bedroom type of an apartment. It does front directly onto the street, but the unit itself seems reasonably have a reasonable amount of privacy. And that part of the street, there is a mixture of residential and commercial uses in that area. It's not in the heart of the core per se.
Any further questions, council? Okay, thank you, Mr. O. Is there any other member of the public that wishes to speak in favor of the application? Anyone that wishes to speak in opposition to the application or in general? Yeah, if you could come forward and just state your name at the podium. Name and address, yeah.
Penny Sure. Address, did you say?
Yes.
Home address?
Hold on, yes,
73 Colburn Street, South Simcoe.
thanks.
The property that is under rezoning, I own the property right beside it for the last 20 years. The new owners have not owned the property dramatically that long. I believe it's 5 years. There's a couple of issues with it. I own 2 retail stores, one in Waterford, one in Simcoe. They're both skirting on the outside of downtown core, like he said. This building is directly beside it. So I think a couple of things. One, you're opening up a can of worms. If you're to convert it to residential, I know that it's illegally non-conforming at the moment, but that's because they chose to illegally rent it out, which I inquired about 10 years ago about doing the same thing, because it's more advantageous for me to take rent from a tenant than it is to run a store and try and make income from it. And I was told that at the time it would not be allowed. These people just simply did it. I'm not sure that that's okay. And I think that I will be your next application right beside, and it is right downtown Waterford. It is in the core. So it depends on what you guys are choosing as to our downtown cores. If you want them rezoned to residential, that's fine, I'm with you. But if you want to maintain our downtown core for storefronts, you better consider this application very closely. This unit also has a very large problem with parking, and it does not already have enough parking for the residential component of it, and it is a war with my parking lot always. The unit itself sits directly on the road. Its frontage is a bedroom, as you asked, which I'm not sure he knows. The entire front is one big window, and yes, they have curtains across it, but it's a bedroom. I've been in there. It's literally one room. It's so small. So I don't know what you guys choose. Those are my concerns. And I think that moving forward, if this one is set forward, I will be your next application for Waterford and then for Simcoe, because our downtown cores are in major duress at this moment. So be careful on your wishes. That's everything.
Thank you. Any questions from councilors? Councilor Huffman.
Thank you, Mayor Chop. Through you too, Penny. So in regards to the physical location of this unit, I know where your store is.
Yes.
So if I'm walking out of your store, to the left or to the right?
Left. I own the side yard, all of the
Right.
property right beside it with the fence.
Yep.
This building's directly adjacent to my side yard.
Okay.
So these guys, I believe, I looked up the property. I believe they've owned it for 5 years. I could be slightly wrong on that. But it has been an apartment for quite some time. And it's a dangerous step. That's all.
So, and just to add upon that, so when you're speaking in terms of looking as to how we move forward, yeah, so then Main Street Collectibles could then
It will
become a
be.
storefront.
It will
and
be.
if other places decide, and then we could.
So it is mixed use, that he's correct. And I have 4 units already in my building. I would love to convert 3 more units. I rent out currently a business right beside me, which is an accounting firm.
Yep.
And then the 2 that are Main Station Collectibles are actually 2 different addresses. There'll be 2 separate apartments. There will be 3 more.
Okay.
I'm your next application for sure. If we want to go that route, I'm with you. I'm not sure I would suggest it.
Now, and I don't know if you don't need to answer this, but just out of curiosity, have you had the chance to speak to any of the other business owners in downtown Waterford and get a sense as to what the thoughts are moving forward?
Absolutely. I've spoken not only to downtown Waterford, but downtown Simcoe, because I'm skirting on the outside of the same core in Simcoe. And there's a strong resilience against the downtown cores being demolished or changed into residential, just because I think otherwise we're dealing with big box stores outside of town, which is a plan. It could be a plan, but you will have all residential downtown, and you will lose your downtown core. There's no doubt about it.
Any further questions from councillors? Councillor Martin.
Thank you, Mayor Chop. I'm not sure if this is working. Through you to Penny, you referenced the parking lot. Is that your lot?
So
There are
there's
12 spaces identified in this. No.
No, that's, I saw, and I went to the courthouse and I researched the properties, and there will be that back parking lot that they have marked out as being theirs. It will be under review. Unfortunately, the person I bought my building from just passed away. He was Stan Mott. He died, I think, about 2 years ago. So I have to go and find original deeds and original zoning and fight their parking, because it's a really big, they have about 3 parking spots right now, and I have about 5, and I have 4 apartments that I'm renting. So there is a public parking lot very, very close to that, right? But again, they have about 8 public parking spaces for downtown Waterford, which is pretty meager.
Thank you. Any further questions from councillors? Thanks for coming. Is there anyone else that wishes to speak in opposition or in general to the application? Of course. If you could come to the podium and state your name and address for the record.
Yeah, it's Michael Bancroft. We live at 1851 Concession 6 Road, Jarvis. We are actually the property owners, my wife and I, and I do dispute some of what Penny is saying. The apartment is a 1-bedroom apartment. Alongside the road is the living room, kitchen area. The bedroom is a separate room to the rear of the apartment, cannot be seen from the street in any way. The apartment, apparently, we purchased the building 11 years ago, actually not 5. And unfortunately, when we purchased it, our lawyer didn't do a zoning search on the property, which is why this never came up. It came up in the fall of last year when we went back to our financial institution to renegotiate the mortgage. And at that point, they asked for a zoning clarification. And I went to see the lady at the zoning office, and she did a search, and that's when she found out it actually wasn't legally compliant. And that's the first time in 11 years that it had been raised. So I went back to our lawyer and to see what could be done. And talking with the building department, the zoning department at the council, and with our lawyer, the best thing to do was to try and make it legal. So we made the application through Civic Planning Solutions to try and rectify the situation that we weren't aware of. Apparently the apartment was put in about 29 years ago, and we're the second owner of the building since it was converted, and it hadn't been picked up since then. The parking area at back that Penny's disputing, we actually, when we purchased the property, we have a survey that you can see on the screen there that shows the parking area at the back, and we actually pay the property taxes on that. We get the tax bill every time, as well as we do for the building. So I'm not quite sure what Penny's going to find when she does the research, but we do have an accredited survey, and we are paying the property taxes, and we have more than ample parking for any of the tenants in the building.
Okay, thank you, sir. Any questions from councillors? Okay, thank you.
Thank you.
Any further questions for Mr. Rowe while he's still here? Okay, Mr. Rowe, do you wish to make any final statements?
So I would. I know this objection raised uh, by the one property owner tonight, and I think this brings into a much bigger issue, the whole issue of how downtown cores function and the need and whatnot to have people living in the core and the evolution of the core. If you look today versus some 50 or 60 years ago, the commercial landscape has changed dramatically. Yet today we probably on a per square foot basis have far more retail space than we did when you consider Simcoe in its heydays being the 1950s and the 1960s. In getting back to this particular unit, we have a situation where there is an existing apartment. It has been there for some almost 30 years. The rents in these units are what considered to be affordable. Certainly, we're going to have to look at our downtown cores as areas where people who need affordable housing will seek to find a place to live. It's being quite clear that we have in this county, we have all kinds of homeless people, homeless families. We have people living in their cars, and they simply need a place to live. Well, they're not about to buy a new home that seems to the price tag these days of $500,000, and that isn't going to happen. We have a homelessness issue here. We have room and availability within our cores to accommodate far more people. There's that aspect of it. But this, in terms of this particular application, we don't see that we are causing any particular problem for the commercial core of Waterford. And in fact, additional rental units in the core will probably enable the service type businesses, because that's who go to the core these days. It isn't retailers, because retailers are in big boxes out on our perimeters of our communities. It's service type uses. In order to have service type uses, you have to have people living there, and I see that evolution taking place in this county, and certainly has taken place elsewhere in North America. Those are my comments.
Any questions from councilors? So I just have one quick question. So what do you say to this constituent's argument then that you know, this is precedent setting for the future?
Every application, I guess, every decision is somewhat precedent seeking. In this particular case, we are in a mixed use area where we do have some commercial, we do have some residential. We're dealing with an existing situation that has been there for some time. And I'll be quite frank, if council were to refuse this and that tenant had to be moved, we're dealing with a person with, I think, severe handicap. And they'd be out on the street. And that's the reality of our downtown cores. I've been at this for 45 years. I've seen that evolution. And homelessness is a major problem in this county.
Okay.
Thank you.
Thank you, Mr. Rowe. Any further questions from councilors? Councilor Columbus.
Thank you, Madam Mayor. I'd like to ask our planners, I know in the town of Delhi we have a BIA, and this using residences at the front of a commercial district is a concern to the BIA. And I'd like to know, there's some kind of a bylaw that we have in Delhi where the front section of the building has to be used for commercial. Is that the same across all the other downtowns?
Through you, Madam Mayor. Yes, the bylaw, there's a zoning bylaw in place that does restrict and direct that residential units shall not be along the street frontage or at the front of the building when you're in a commercial zone. Our official plan has similar policies in it. And that's what this application is seeking to amend on a site-specific basis so that they can have that apartment at the front street level of the property.
Thank you.
I just have one question, Shannon. Is there at any, like, when this speaks of non-conforming, it's not referencing legal non-conforming, so there would have been at no time that this would have fallen within a previous bylaw to justify, or would it?
Through you, Madam Mayor, no, that's correct. Because there was never permits, never anything issued to recognize the unit at any point in the past, it doesn't have or carry any kind of legal non-conforming status to it.
This is kind of a tough one. So, in your view then, I mean, when you look at applying this on an equitable basis for all of Norfolk County, I mean, just because somebody did it illegally years ago and now they're coming forward, shouldn't really distract from somebody that wants to do it legally now.
Through you, Madam Mayor, no, if this had been brought to our attention, we would, like any application, look at everything on kind of a site-specific basis, evaluate the merits of what's being proposed with respect to the buildings themselves, the area that they're in, and the intent of the property in itself. So we don't necessarily see it as precedent setting because we would want to look at anything on a site-specific basis, and the bylaw will still apply to all the other properties within the downtown areas. So if somebody else wanted to convert in a similar manner, they would go through the same process.
Okay. Any further questions from councilors? Councilor Rabbit.
Thank you, Madam Mayor, and through you to staff. I'm hoping I can turn this into a question, but it might be more of a statement in just terms of my perspective on the issue. I would like to work towards an ideal circumstance. I know that there are a lot of concerns with these street fronting apartments where there is a significant lack of privacy. We have circumstances where the drapes are not drapes, they're towels or they're blankets put over a window. You have someone either bathing in that front window as passers are going by on the sidewalk there, and there's a significant lack of privacy in many of these residences that are fronting directly onto the street. What I've seen done in other municipalities is they craft a bylaw and they put a little bit of a separation in place. You have a common area, perhaps this is a place that's locked, you have mailboxes, you have an area that's just a barrier between that domicile and the sidewalk. And this is an ideal that I would like to perhaps explore further and work towards. I think in this particular instance, we're dealing with a one-off and we're not precedent setting. I'm of the opinion that, and this is one councilor's opinion, that is not a detriment to have people living in our downtown cores. They're out spending money, they're residing there, they're frequenting and patroning those establishments that are their neighbors, and this is not something that's going to be a detriment to our downtown, having people reside and live there. And I would be very interested in further applications in that regard. I want to make sure that we're doing it right and we're ensuring that this person is going to have the adequate privacy and we're being respectful of our neighbors, whether they be commercial businesses or other residents in the area. And for those reasons, I would be supporting this particular application. But I'd like to hear some comments from our staff based on some of the comments that I've made about that buffer zone. Is this something that we're able to do with future applications, or possibly visit the bylaw itself and look to having a common space, provide a buffer between the street and those domiciles?
Through you, Madam Mayor, to Councilor Rabbits. Great points that you've raised there, and it is absolutely something that we can kind of consider for future applications if we get others of this nature. So noted in terms of going forward. I think it's something we can take into consideration, so thank you for your comments.
Thanks, Shannon. Any further questions? Councilor Huffman.
Thank you, Madam Mayor. Through you to Mr. Rowe. So I just wanted to clarify, the individual who is currently living in this apartment, who unbeknownst until this past fall was legal, illegal, non-conforming, how long has this individual been living in this particular residence?
I don't know.
Okay, with Mr. Bartlett or Mr.
How long? Just over a year.
Okay, and prior to that, this unit was rented?
I would assume so, yes.
Okay, I would kind of like the answers to the
Yeah,
questions.
if, want to come and join me.
Need the answer.
Hi.
Hi.
Sorry, yes, when my wife and I bought the building 11 years ago, the apartment was already rented. We took over the existing tenants. Like I say, our lawyer unfortunately didn't do a zoning check. If he had, and this had come up, we probably wouldn't have bought the building. But because we found out last September that the ladies in the office said we didn't really have to do anything to it, but we wanted to make it legal.
Okay,
That's
so
how
I
we are.
understand that part. So prior to the individual, the current tenant who's living in there, previous to that, was there a long-term tenant, or is this typically
The tenants,
a transient unit?
on average, stay a couple of years. Generally, they're either young single people who are trying to get a start so that they can move on to something bigger, or the older people that are downsized, looking for somewhere affordable to live, and then after a couple of years, they end up moving into a retirement home or something like that. So it kind of serves two needs.
So essentially, this unit has been rented out for pretty consistently for 11 years.
Well, we've had it, and it was rented out, like I say, it was converted 29 years ago.
Okay, great.
Thank you.
Thank you. Any further questions from councilors for staff? Okay, if I could have a verbal motion then to close the public meeting. Councilor Rabbit, seconded by Councilor Van Passen. All those in favor? And that's carried. Now comes the tricky part, I guess. Would somebody like to move the staff recommendation or propose an alternative? Councilor Rabbits.
Thank you, Madam Mayor, and through you, I would like to advance the approval as printed on page 148 of our agenda. I will move it.
And do I have a seconder? Councilor Hoffman. Okay, any further discussion on the motion? Councilor Columbus.
Yes, the recommendation as in that no public input has been received, and we did receive public input, so that should be taken out of the
We'll
recommendation.
strike that from the record. Any further discussion? Councilor Martin.
Thank you, Mayor Chop. I think I would just like to take advantage of this opportunity to say that I think there is merit in our downtowns to have foot traffic when we look at empty storefronts as the comparator. Would we rather have people residing in our communities and spending their money and bringing their friends and family, or would we rather have an empty storefront? But that being said, it needs to be very strategic. I think that we need to, as this council, have a better plan to what that may look like if that is what we want to do. But I would be supporting this based on the fact that it is already existing. Thank you.
Thanks. Any further discussion? Okay, we'll public vote. All those in favor? That's been carried. Next one is DCS 19-39. That's regarding an application that has been received to consider an amendment to the Norfolk County zoning bylaw to permit a place of recreation and a secondary dwelling on a temporary basis. Jonah Logan, on behalf of John Richard Logan, has put forth the application affecting the lands described as 301 Jenkins Road in Scotland. I now open the public meeting on staff report DCS 19-39, and Ms. Van Dalen, if you could please present your report.
Thank you, Mayor Chop. This application is a zoning amendment for a property located at 301 Jenkins Road. It's approximately a 45-acre property with an existing dwelling on it, a secondary unit, as well as an existing place of recreation. This zoning amendment is to recognize and legalize the Circus in the Trees operation, as well as recognize a secondary unit on a temporary basis for a period of 5 years. The application and amendment will be recognized on a site-specific basis and is considered to be a good use of the property and add an on-farm diversified use, as well as recognize an economic and tourism opportunity for the subject lands. The application was circulated, and through the circulation process, there was no comments received in terms of negative input to the application, both from the departments and agencies as well as the members of the public. And based on the foregoing, staff are recommending support of the application, and I'm happy to answer any questions that you might have. Thank you.
Okay, thank you, Ms. Van Dalen. Is the applicant Jonah Logan in attendance or an agent on his behalf? If you could come forward, sir.
Hello, I'm Jonah Logan, 301 Jenkins Road, Scotland, Ontario. I'm just here to field any questions.
Okay, any questions from councillors? Councillor Martin.
Thank you, Mayor Chop. Through you to Mr. Logan. There is a comment in the report that this bylaw amendment proposes a limitation of 6 events per year. Do you have any comments on that?
That should be more than enough if that works for you. That's great.
Okay, any further questions from councillors? Councillor Van Passen.
Madam Mayor, I do have a question for staff, though. It's a temporary use bylaw for a garden suite is for 5 years.
Can we just finish with the application here and then we'll move over to questions for staff? Okay, any further questions from councillors? Thank you, sir. Is there anyone else here that wishes to speak in favor or in favor of the application? Is there anyone else that wishes to speak in general or in opposition to the application? Okay, in that case, any questions of staff? Councillor Van Passen.
Yes, thank you, Madam Mayor. Through you to staff, why is it that they're going for 5 years for a garden suite? I thought our standard was 11 years and then 3 and 3 and 3.
Through you, Madam Mayor. The 5 years was based on discussions that were had with the proponent. They've got their plan for the next few years, and 5 years was what they were seeking and asking for. So it's not kind of your typical garden suite. It's the temporary dwelling that we're recognizing. So that's why you see the deviation from the 11 years to the 5. It is based on a lot of the conversations with respect to the subject lands themselves.
Thank you, Ms. Van Dalen. Councillor Columbus.
Thank you, Madam Mayor. If in fact it is a temporary use for 5 years, why is it not in the recommendation? I think it should be part of the recommendation because it is pretty important. Can that be added?
Through you, Madam Mayor. Yes, so with respect to that, it's to recognize the temporary use as well as the place of recreation.
Okay, that's not spelled out in the recommendation, though.
Yeah, I see that, and it should be. So thank
Okay.
you for bringing that
So
up.
it should be added in there. Somewhere be approved for a temporary period up to 5 years. Right?
Correct, thank you.
Good enough, thanks.
Councillor Columbus, if you'd like to.
I will move the recommendation as printed on page 164, and after the words "be approved," submit for a temporary use of up to 5 years for reasons set out in report number DCS 1939.
Okay, thank you, sir. Can I have a seconder? Councillor Taylor, any further discussion? All those in favor? And that's been carried. Next one is DCS 19-59. That's regarding an application that has been received to add a special provision to permit a minimum lot area of approximately 16 hectares and to permit a contractor's yard and landscape supplies operation on the subject lands. Bill and Selena Thompson, on behalf of Robert Walker, Smythe Estates, and Agent Brimage Law Group, have put forth an application affecting the lands described as Nanticoke, Ontario. I now open the public meeting on staff report DCS 19-59. And Ms. Van Dalen, if you could please present your report.
Good evening. Excuse me. Good evening again. This application is to consider an amendment to the Norfolk County zoning bylaw to permit a contractor's yard and landscaping supplies operation on the subject lands, as well as recognize the property with a minimum lot area of 16 hectares. The application was seen before the Committee of Adjustment in March to split the two farm parcels and recreate the lot lines that previously existed. So that's where the request for the 16-hectare lot size is coming from. The amendment with respect to the contractor's yard and landscaping supply operation would be for a portion of the property, approximately 4 acres, at the front of the property and adjacent to St. John's Road. The application was circulated to the various departments and agencies who did not have any concerns with the proposed land use, as well as to members of the public, and no comments were formally received with respect to that. However, I did field a few phone calls in terms of the operation. It is noted that the proponent has started some groundworks on the site, and this will recognize the use in terms of moving forward. The bylaw also includes site plan control to be applied, which would be addressed in the future if any proposed buildings or expansions are proposed for the subject lands. Based on the foregoing, staff are recommending support of the application, and again, I'm happy to answer any questions that you might have. Thank you.
Okay, thank you, Ms. Van Dalen. Questions of council? Council Rabbits.
Thank you, Madam Mayor, and through you to Shannon. I'd like to provide you an opportunity, Shannon, maybe just to elaborate on the groundwork that's been done to date. I've also fielded several phone calls concerning the usage on an agricultural plot of land and starting industrial applications. Others have been, that have gone through this process have been told they need to seek out a zoning change first prior to any groundwork being done or relocate to an industrial zone. And I was just hoping maybe you could elaborate on what actually has been done to date and maybe dispel some of the rumor or the conjecture about what activities are taking place on this site.
Through you, Madam Mayor, I'm happy to try and address some of those questions. Mr. Kolomaya is here as well, and he's representing the applicant. He may be able to address some of those questions specifically as well. There was a permit issued for a building. It was applied for as an agricultural building, which is permitted as of right under the zoning. In terms of some of the earthworks and ground movement, some properties are allowed to do some works to their properties themselves, so we can't really look at having some controls that way. I know bylaw enforcement has been out to the property as well to talk to Mr. Thompson just with respect to the use and to operation, and has had some conversations to the extent of fully operating on site. And given the nature of the business with some seasonal concerns, I know they are trying to move forward quickly and get everything set up so that they can operate legally as quickly as possible.
Any further questions? So I guess I appreciate them wanting to get set up and operating as quickly as possible, but maybe you could just elaborate a little bit more with some of the groundwork. I've had a number of phone calls as well and talking about concrete that's been poured outside. Would you need a permit typically for that?
Through you, Madam Mayor, yes. Depending on the types of structures that are being built, but I do know for some of that they are permitted as of right in the agricultural area. So if their permits are coming in under the agricultural buildings, which could be used regardless of if it's for the landscaping operation or if it's for an agricultural use, the buildings themselves don't constitute the use in what's happening on the property.
I think, though, it's pretty obvious if you've driven by there, though, that the concrete that's being poured is being used for the business, not for an agricultural purpose.
Through you, Madam Mayor, yes. However, when the permits come in, unfortunately, if it's for an agricultural purpose, we don't have any grounds not to issue the permits at that time. If they are used for a use other than agriculture, then it would come from an enforcement perspective as to whether or not or how that's functioning on the property. But in terms of the permits and the construction, if they're coming in for the agricultural use, those are permitted. Or agricultural function, those are permitted, but it comes down to the use at the end of the day, how they're actually operating on the property. I hope that helps to somewhat adjust the question.
Sort of. Okay, thank you. Is the applicant, Jonah Logan, in attendance or sorry, am I at the right one? Yes. Next one. I guess, Mr. Colomaya, you're going to come forward to speak on behalf of the applicant. How did I miss it?
Good evening, Madam Mayor, and through you to the members of council, thank you for the opportunity to speak this evening to this application. As mentioned, I'm Nathan Colomay. I'm a lawyer with the Brimage Law Group. My primary practice areas are municipal and real estate law, and I'm here as agent on behalf of Bill and Shalita Thompson this evening. And as an aside, my firm, we also act for the current owners of the property, the Robert Smythe estate, which has consented to this application. And we appear before you this evening to ask that you approve our zoning amendment application as per the recommendation in the report. We agree with Ms. Van Dalen's excellent report that this application conforms to our planning, legislation, and policy framework, and in general will be a great thing for Norfolk County. And just to give you a quick overview how we got here today, the lands are currently owned by the estate, and what happened was, over time, Bill and Shalina have farmed it the last couple of years, the whole property, and because originally there were two parcels, which is why you heard some mention of the Committee of Adjustment. So we applied for both this zoning amendment and the severance application back in December, and the severance application was heard in the February Committee of Adjustment meeting. And this application as well for the zoning was supposed to be heard back in April. So we've been our firm, Venture Norfolk, and the other organization providing the funding that will for the eventual purchase of the severed parcel. We've all been working very, very hard to get this done ahead of time. And what happened was, it was supposed to come for, I believe it was your April or even a March meeting, because of everything else that happened. I think it was with Clonmel. It got bumped to this meeting. So we've been working in good faith to have everything done, to a T, before operations. But we got, stuck between, no pun intended, a rock and a hard place. Do we wait a few weeks and so we're absolutely, perfect on everything, and which would crush the business? Last year, I believe it did over $500,000. I think we're on track for $750,000 this year. And we employs, I think, 3 full-time employees aside from the Thompsons themselves. Or do we push ahead, continue to farm the property, sort of get things rolling for the business, and then when the zoning is done, we're all good to go and ready to continue on for another season. So the reality is that without this application, that's more or less it for the business. And we've really worked hard and done our best to get everything done ahead of time, but just the way things worked out with scheduling, here we are tonight, into the spring season. And and this is the last piece we need. We've gotten the property ready, we got the severance done, so this is the last thing we need to really allow a locally owned and operated business to flourish and to move forward. So if you have any questions, I'd be happy to answer them.
Okay. Can I ask one quick one? I know, with all due respect to some of the constituents that have called in with their concerns, I don't believe that it was Clonmel that kind of what was the changeover period. Some of the business was operational, or some of the concrete pouring was being done prior to the Clonmel application. So it wasn't because of the delay with Clonmel that this started happening, because I heard about it long before Clonmel.
Okay, and honestly as well, the property is still actively farmed by the Thompsons. So yes, there is their main business, which is the landscaping and agricultural supply. They provide all kinds of products to our local farmers, but they do actively farm the property as well.
Okay, and are you aware of a bylaw that prohibits topsoil being removed from agricultural land and being sold? So are you able to confirm that topsoil is not going to be sold?
I don't believe the topsoil will be sold, but I have to ask, removing topsoil, right?
Hi, I'm Bill Thompson from Thompson Landscape Supply. 329 St. John's Road is my address. The topsoil issue is a byproduct of the expansion. Like any expansion or any building that happens in town, nothing can be built on topsoil. So that material needs to be removed. Whether, given this circumstance, I'm the guy that moves it and retails it, it would be no different than somebody coming in and clearing a bush lot and selling the trees off and making a profit from them. A portion of the topsoil that is in our pile currently is from the property, but there is topsoil we farm from other areas. We buy from contractors and different projects all over Norfolk.
So there won't be topsoil removed from other parts of the farmland then?
No, we've done our best to create green space on the farm, and 4-acre parcel over 40 acres is quite minimal, right?
Okay.
And it's not like it's free grab money. We've created a semi-permeable pad on that area too.
So, I mean, we'll proceed with the rest of the public meeting here, but I think that I think that this council as a whole supports any new business that's starting up in Norfolk and so on. I think part of the frustration from some of the other residents in the area, though, is the fact that, I understand things, they're still challenging. They've definitely been challenging in the past. We know that. We're working to try to, everybody, staff and council, we're not there yet, definitely, but we're working to try to improve things. So it's a point where do you draw the line where, people that have called up have said, listen, I support this business, but, I followed the rules and, now this guy comes in, and isn't. So it's a tough spot. You support the business, but at some point, there's going to have to be a change over here where council is going to have to start saying, if you don't follow the rules to get things done to ensure that it is on an equitable basis across the county, that we aren't going to support it.
Madam Mayor, if I may speak to your comment. In terms of my preliminary due diligence for the property, there's a full-blown gravel pit right next door. And in terms of this property being used, my opinion would be that as of right, they could operate their business here. So the purpose of this application is really say, hey, we're going to operate this business here, and we want to be as transparent as we can. So that's part of the reason why you're here tonight is for that clarification, because I think as of right in the zoning bylaw itself, we would be able to pursue the operations as is.
Okay, but you did just admit that you were moving ahead with things before you had all of your I's dotted and T's crossed.
Oh, yeah, 100%. I mean, beginning my presentation, we have started. Yeah.
Okay.
Thank you.
I think Councilor Martin had a question.
Thank you, Mayor Chop. Through you to Nathan or Mr. Thompson. So just so I'm understanding, I would agree with Mayor Chop that I think there's this perceived notion that this new council is coming in to do things differently and address how things move through any such department. But there's a little bit of a catch-up period where we're not able to just wave a wand and have this happen. So for you to wait, you were saying the business would not have survived. Was that accurate representation? And additionally, on the same road, there are other commercial businesses, correct? And industrial. Okay, thank you.
Any further questions? Councilor Van Passen.
Yes, thank you, Madam Mayor. Jumping the gun is one thing, but a year and a half ahead of schedule, that's pushing it a little bit. But I do have a question. Mr. Kulamaya said that it can do this as a right. So I'm just wondering, does your client have a farm business registration number? And I'd like to know what crops he actually grows.
No, I don't currently carry a farm business registration number, but on the acreage. Half ahead. We haven't retailed off that site for any more than a month. Anything that I've done in the past has been all by the permits I've obtained through the county for my road access, for my grading, the bins, the building, everything has been permitted. So yes, unfortunately, we did operate in a situation where we probably weren't given the right to yet, but it was one of those calls you have to make, whether you step back and let your business fall apart, everything that we've worked hard for, or, you know, you jump the gun a little bit.
Councilor Van Passen.
Well, I'll be the bad guy, I guess, but I'm assuming that your solicitor has advised you that potentially this council can say no, and then all that investment in that business would be lost, because I too have had more than 25, 30 calls about this, and everyone is about the same, that it's just wrong, but nobody wants to stop the young fellow from operating a business and creating a job. And, you know, pushing the envelope, I would say a bit more than a month. I would go back to, you started work, you were building it, you were doing it all at least a year and a half ago. The reason I asked a question about the farm business registration number, and because of the discussion of as a right, because unless you're a farmer, the provincial policy statement says a farmer has a right to do certain things. The official plan says a farmer. The zoning bylaw says a farmer. It's not somebody just buys a farm and he's allowed to do whatever he wants, because I think another councillor has brought this up. There's been other people that had the same idea and they were forced to go to an industrial zoning where it isn't allowed use. And I have a terrible sort of dilemma in my mind for those same reasons. Don't want to stop a young fellow from starting a new business, but we still have to follow some rules whether we like to or not. So can you comment on that at all, Solicitor?
Well, a couple of things. One thing that was brought up in the Committee of Adjustment was the whole issue of agricultural land. And in the provincial policy statement, it's prime agricultural area if it's one of two things, or both. Either it's a specialty crop area, which this property is not, or it's, you know, class 1, 2, or 3, and the land inventory, which this property also is not. It actually is, I'm not sure if it's a mix of 4 and 5. So it's not prime agricultural land. And really what it comes down to is not who the operator is, but what the use is. It's zoned agricultural, and in terms of, you know, complying with the rules, that's why we're here tonight, is to seek this, you know, clarification, just to make sure that it's abundantly clear to us and to everyone else that this particular business is permitted on this property and the front section of the property, because the rest will remain unchanged, agriculture and hazard land.
Any further question from councillors? Thank you, sir. Is there anyone else that wishes to speak in favor of the application? Is there anyone here that wishes to speak in general or against the application? No. Okay. Any further questions from councillors to staff? Could I have a motion then to close the public meeting? Councillor Martin, seconded by Councillor Huffman. All those in favor? Okay. And is there someone that would like to move the staff recommendation or propose an alternative? Councillor Martin?
Thank you, Mayor Chop. I would like to move the staff recommendation as printed on page 176.
I have a seconder. Councillor Geisens. Any further discussion? Councillor Columbus.
What I find interesting about this one is the fact that we've all received all kinds of emails and phone calls about this, but nobody came to the podium to object.
Well, I'll do, kind of respect our constituents. One woman, I think was elderly, actually, to be honest, and had concerns about coming to the meeting and so on. So, but I agree. I'm surprised there's nobody here either. Any further discussion? Councillor Van Passen.
I want to go through a little bit of this. I've underlined a few things in the report. This is from the provincial policy statement. Prime agricultural areas shall be protected for long-term agricultural use. Whether that's class 1, 2, 3, 4, 5, that is some of the nicest farmland around. It's a heavier loam, but it's a gravel base underneath, so it's well drained. It grows everything. It's a beautiful little piece of property, especially when it was part of the bigger farm. We go to the official plan. We have an opportunity for businesses that support agricultural operations. I've heard a lot about the great and wonderful agricultural products they have there. I think they serve the rural community very well. They serve the urban community very well, but I don't think I can go there and get 4 ton of fertilizer in a spreader. I can't pick up herbicides, pesticides, anything to that. I think it's a stretch to consider that an agricultural operation or supporting the agricultural operation. Go to the next page. We allow this by providing opportunities for farm operators to engage in a secondary business activities that supplement the farm income. I'm not so sure that it is a farm operation because the province of Ontario requires a farm business registration number and the fees associated with that in order to have it. The bottom of page 175 of the agenda, it says the contractor's yard and landscape operation are permitted in other rural zones, including hamlet commercial, rural commercial, and uses commonly found within the agricultural area. Now, unless I have an outdated copy of our branding zoning bylaw, I believe that's incorrect. They are only allowed in the industrial zoning. They're not allowed anywhere else. Part of my little rant is going to be about the way the province sets up the rules that we have to work under. You know, the nice people that work in a nice office in Toronto decide what we can and can't sever, where we can do business. If you go directly across the road from this property, there's a little parcel about 3 acres that is physically separated from the rest of the farm by a gully. So it's totally useless little piece of land. We're not allowed to sever it. We're not allowed to put a different use on it because the provincial policy statements say we have to preserve prime agricultural land. But at the same time, we can take the piece on the north side of the road, we can strip off some of the nicest topsoil in Norfolk County, we can shove it on a pile, and we can start filling it full of cement and stones and run a business out of there, but that's acceptable. That's my little rant, but I do have one actual question. Because we are sitting as the planning committee, are we allowed to abstain from voting, or do we have to vote either yes or no? Because I have that same problem as all these people that called me, all the ones I talked to, that I don't want to stop a business from operating, but where it is and how it was done is just plain wrong.
I'll defer that question to our clerk.
Through you, Chair. Unless you have a pecuniary interest, a conflict of interest, you can't abstain. So you would, your option now is to get up and leave the room quickly.
Councillor Martin.
Thank you, Mayor Chop. Again, I hear Councillor Van Passen's concerns about how and when, but I also hear a lot of concerns about how this maybe has gone through our planning staff and provincial regulations as well. And I don't know if you've taken a drive down the road. I think the business looks beautiful and would be an asset to Norfolk County, and I would rather focus some attention on working with our staff to ensure that we can assist businesses better and sharing a clear mandate of what that looks like when we start to work with business owners. Thank you.
Any further discussion? Okay, I guess we'll take a vote then. All those in favor? Opposed? Well, it's carried. I guess, Mr. Thompson, when I wasn't allowed to participate in the debate, but for myself as well, I was trying to find a way to fine you. But I haven't found one yet. So if anybody else is watching, by the time somebody comes forward again the next time that has done something in advance of actually receiving the permits, I hope that we will have come up with something creative, a way to get around it. But I hope in the future, if you have further development or construction on the property, that I know it's been challenging here in the past, but that you will come forward and go through the proper channels. Okay, next before us is what everybody's been waiting for, DCS 19-45. This is in regards to an application that has been initiated by Norfolk County to amend zoning bylaw 1Z 2014 schedules to update the boundaries of provincially significant wetlands as determined by the Ministry of Natural Resources and Forestry Evaluation Wetlands. Norfolk County has put forth the application affecting all lands within Norfolk County. So, before we begin, I just want to say a couple words, since we have so many people here this evening. The first thing I want to say is that I think it's fair to say that all council members at this table, if not all, I haven't spoken with everyone, but certainly a majority of the council members support the property owners that are here today opposing the adoption of the provincially significant wetlands into our official plan, and agree that the wetland evaluation system is fatally flawed. We will not be adopting these changes today. I believe that a motion will be put forward to defer this matter until we've had a chance to have conversations on behalf of all citizens affected by this designation with the province. That said, since everyone is here this evening, in order to preserve your rights, you are allowed to come forward to the podium, or we are also providing a sign-up sheet. So if you do come forward to speak, if you could ensure that you're please not repeating something that someone else has said, to keep it brief so that we can all get through this evening as quickly as possible. Again, you don't need to speak. The clerk has a sign-up sheet, and that alone, or with the letters that you have submitted, are sufficient to preserve that right to appeal in the future. So, with that, I would like to open the public meeting on DCS 19-45, and Ms. Call, if you could please present your report.
Okay, thank you. This is a proposal by the Planning Department to update the existing provincially significant wetland zone to match the updated provincially significant wetland designation in the official plan. Approximately 1,200 properties are affected, and a notice was individually mailed to each property owner notifying them of the proposed changes. So if a notice was not received by a property owner, that means they are not affected. An open house was held on April 11th to provide additional information, and staff have responded to hundreds of inquiries regarding the proposed changes. The PSW zone first came into effect in 2015, and all affected property owners were notified in 2010 and in 2011. It is now being updated based on the latest information as provided by the Ministry of Natural Resources and Forestry, or the MNRF. Norfolk County uses the MNRF PSW designations to create the PSW designation in the official plan, which is implemented through the zoning bylaw. This is not a policy project. There are no new PSW policies being proposed. This is simply an update to the existing zone mapping to ensure accuracy. There are no new buffers proposed. 120 meters around wetlands are regulated by the Conservation Authority, regardless of whether or not Norfolk County has a PSW zone at all. The existing zone does not include the buffer area and is not proposed to be included through this update. PSWs are regulated by the Conservation Authorities, regardless of whether or not they're zoned by Norfolk County. The purpose of the zoning is to assist landowners in understanding where the PSWs exist and to increase transparency. This change has been proposed by the Norfolk County Planning Department. There have been questions relating to who is behind the project, and it has been completed independently by Norfolk County using the MNRF's mapping. There has been no involvement from the Long Point Conservation Authority or the Nature Conservancy of Canada or any other special interest groups. It is important to note that this is just a technical mapping update. It is not a natural heritage plan like what was completed in Huron County, and it is not a natural heritage system study similar to Perth County. It is just an update to a map schedule that already exists in Norfolk County, and many of the changes are very minor in nature. So this map on your screen is an example of why the update is required. So the blue areas outline the PSW designations in the official plan, which was adopted by Council previously and approved by the province last fall. These designations match the information on record with the MNRF, and previous to the official plan 5-year review, the black zone lines shown on this mapping matched the blue designation.
Since the designation has been updated, the zoning no longer matches, and the information in the zoning bylaw schedule is no longer accurate and requires updating. So what are wetlands? They are defined in the Ontario Wetland Evaluation System Southern Manual as lands that are seasonally or permanently flooded by shallow water, as well as lands where the water table is close to the surface. In either case, the presence of abundant water has caused the formation of hydric soils and has favored the dominance of either hydrophytic or water-tolerant plants. Wetlands are not required to be wet year-round. The existing PSW zone in the county zoning bylaw does not permit new development. Agricultural uses can continue, and if an irrigation pond is considered to be part of a PSW, it can continue to be used for irrigation with no problems. The PSW zone can be modified on a site-specific basis without going through the formal zoning bylaw amendment process, as it is understood that PSWs can change over time. Staff are recommending that council approve all of the proposed changes as presented. The MNRF has designated all of these areas as PSW, and as such, there is no true justification at this time for not making the changes. The lands are currently or will be regulated by LPRCA or GRCA, regardless of whether or not the zoning is implemented. By not making the changes, the zoning bylaw will remain inconsistent with the official plan, and landowners may not be accurately informed of the designation on their property. Staff have included options in the report, including options for deferral. If council does choose to defer the amendment, staff suggests a deadline of December 2019 to return to council for a decision. The MNRF will generally not adjust any boundaries unless an evaluation has been completed by a qualified wetland evaluator in accordance with the Ontario Wetland Evaluation System. The PSW exists whether or not it is zoned as such by Norfolk County, and the current zone mapping is inaccurate right now. A deferral will not serve any purpose unless evaluations are completed for the PSW boundaries being questioned. I am happy to answer any questions that council or the public has.
Thank you, Ms. Call. Questions of council? Councilor Rabbits.
Thank you, Madam Mayor, and through you to Alicia. Thank you for your presentation. Alicia, I want to know what a property owner can do in terms of appealing these designations. I realize that we're caught as sort of a messenger in this scenario between the province, their designations, and our own official plan. What can an individual do if we were to adopt the recommendations as presented, or in the event that we do end up deferring? What's the process that's in place for an individual to actually appeal to a higher level of government?
Through the mayor, so just to clarify, do you mean if someone wanted to appeal the zoning bylaw changes? Okay, so they could appeal to the local planning appeals tribunal. It would go to what formerly was the OMB, and they would have the opportunity to have it heard at that level. But generally, I don't know if the LPAT, what decision they would make if there was no information to show that the mapping is wrong. It would be more so, I think you would need that Ontario Wetland Evaluation System evaluation completed to have it changed. And we can do that just on a case-by-case basis already without having to go to the LPAT.
Thank you. And further to the point, would these property owners be able to appeal that zone should this council defer your recommendation? Would they be able to do that in the interim, or are they going to have to wait till we deal with the deferral?
Through the mayor, they are able to appeal a deferral by council. But it would be that deferral decision that would be appealed.
Councilor Huffman.
Thank you, Mayor Chop, through you to staff. So Alicia, what is the, what's the detriment to a property owner having PSW designation of their land?
Through the mayor, generally it just means you can't drain it and you can't build in it. So if you already have a property that part of it is zoned as wetland, let's say in your back bush, and you've got buildings, barn buildings, a house on the front portion, effectively nothing will change. And there's been some questions about spraying and farming within the buffer area as well, and that is permitted. Existing agricultural uses are permitted to continue. What I've learned from the MNRF is generally you just can't drain the wetland and start farming that area.
Councilor Michelli.
Thank you, Madam Mayor. Alicia, through the mayor to you. Um, Alicia, you just mentioned that you can't drain the wetlands. So I'm just curious, if the property owner has an irrigation pond on their property and they pump water out of it to irrigate their field, would that not, according to the definition, be draining the wetlands?
Through the mayor, I did ask MNRF staff the other day about using irrigation ponds that are designated as wetlands, and they indicated that it's fine to continue using them.
Alicia, and I'm in no way trying to put you on the spot here, but I just, if I had an irrigation pond on my farm, I don't know if I would take that as much of a guarantee that they said, oh, it's okay to do that. You understand what I'm saying? Like, I would want something in writing in the paper, and I'm not sure that I've been able to find that in any of the documents that I've looked at. So thank you for that. And Madam Mayor, if I can ask another question.
Sure.
On page 9 of your report, under the heading of strategic plan linkage, it indicates, it's on page 189 of our agenda package for council. It indicates that this is related to goal number 2 of improved essential infrastructure, and that provincially significant wetlands play an important role as a part of our natural environment, and that their protection should be of the utmost importance. And I think everyone in here would agree with that. I think my question is, are you aware of, in Norfolk County at least, of significant violations of the provincially significant wetlands that we currently have by residents?
Through the mayor, no, I'm not aware of any such cases.
Councillor Columbus, I believe, is next.
Thank you, Madam Mayor. To staff, Alicia, what do you expect the changes will be between today and December?
Through the mayor, it would be, I don't anticipate really any changes unless the evaluations are completed. So if council chose to have the certain properties evaluated, then there could be changes to those boundaries of those PSWs, but otherwise I don't see. The MNR, I've talked to them extensively. They generally won't make any changes unless the evaluation has been completed.
Thank you.
Could you mind if I jump in with just a question? Are you aware that the government is currently under a consultation period right now? It's still open for the next 46 days to reevaluate what the definition of a wetland is?
I wasn't aware they were reevaluating the definition of the wetland. I knew about the buffer area could be reduced to 30 meters.
It says, for the purpose of this new regulation that's going to amend the Conservation Act, the ministry is also proposing to update definitions for key regulatory terms, including wetlands. I think that there's a significant review that's being undertaken by the ministry right now under Premier Ford to reduce some of the red tape and so on that goes along with this situation of preventing development on these properties. And I'm just wondering if it, might have maybe been prudent to wait until that consultation period was over before Norfolk County.
Through the mayor, this was initiated before that information came out. So the official plan review was completed in the fall, and then we started working on this, and there's been a lot of changes with the new government.
Okay, thanks. Further questions? Councillor Van Passen.
Yes, thank you, Madam Mayor. Planners told us that they've had extensive discussions, but what happens when the MNR's mapping is just outright wrong? I'd like to see the study they used to arbitrarily draw these lines, and if we asked them to change it, are they actually going to come and physically look at them this time, or are they going to make us go out and have somebody walk the properties, or each individual farmer has to hire somebody to analyze the property and then send it back to them? Or can they just sort of agree with us that, oh my God, that is a municipal drain that runs through 4 straight concessions in a perfectly straight line, and it's probably not really a municipal or a provincially significant wetland? Or, maybe we'll take those pictures in August instead of in April, and all of a sudden there won't be water laying there. And so is there room to have discussions with them that we could point out a few of their errors, or do we have to hire consultants for this?
Through the mayor, I did ask the MNRF staff to attend several times, and they are not able to. And I know, again, sometimes the areas will be dry in the summer, wet in the spring and the fall, but the message I've received from them is they generally won't change anything unless there is individual evaluations completed. I know there's been one case that is a sandy lot at the beach that they will remove it from, so certain cases like that, but generally on farms, they haven't agreed to make any changes.
Further questions? Councillor Geisens.
Thank you, Mayor. Basically, what I'm looking at here, and I hope it's working here, I'm looking at what M&R is doing. We're looking at it and saying, well, I don't know where the 120 meters came from. It may have been there before or whatever, but that's not what we certainly haven't been using. And people are upset, no doubt about it. They have a farm. They're being told that they can't do basically what they can on their farms and everything like that. And I'm not saying that some of it will have to happen, I guess, but I think it's important. And what I'm suggesting is that we hold DSC 1945 to what we have here till December as what we were telling us. So theoretically we have some time, and these people out here today may have some time to make some changes as far as it comes along. So to me, I would suggest that I'm a farmer as well. Unfortunately, or fortunately, I guess, I don't have a wetland on my property, but I still am a farmer, and I know how all of you feel. So I'm hoping that something will change. Certainly, I don't think it was Norfolk County that was doing this, but it was a program, and I believe it was through an airplane and LIDAR, I think it was, what they did, most of Norfolk, certainly Norfolk County and maybe the rest of Ontario. I don't know. So those are the things that we're looking at, and I'm hoping, and what the mayor just said, I think it may be important that Mr. Ford may want to have his people look at it and say, what can we do differently so these people aren't going to have to go through a whole lot of, I guess, whatever they don't want to go through. They want to do they want to be farmers. And in some places, there are some people who may have a lot that's not that far away from a wetland that they had it before. Now I don't know whether they're going to be able to use it or not. And those are all the things that people are talking about out there. So I'm hoping that the M&R or whoever will do something that will actually make it easier for all. So thank you very much.
Thank you, Councillor Geisens. Councillor Michelli.
Thank you, Madam Mayor. I just want to add to what Councillor Geisens is mentioning. One of the biggest problems with all of this, and that's why so many people are here today, and I'm so proud of all of you for coming and showing your support for this and showing your concern. But I just want to mention also that this just creates, the thing that we don't want in our lives is all this uncertainty of our properties, what we want to use in the future. All of those things are at risk here, and I'm hoping that a deferral of this proposed amendment will simply give us some time, because the missing piece in this whole puzzle is we have yet to hear directly from people in the Ministry of Natural Resources and Forests directly why this is being done in the way that it's being done. And I think that between now and then, hopefully, we can get some answers to those questions. Earlier, I asked Alicia if she was aware of if there had been any violations of the PSWs on anybody's property in Norfolk County. She indicated that there has not been, to her knowledge, no violations. And that's because all the people in this room are very good stewards of the environment in the first place. And that's why you're here. So we need to get much better information and much more accurate information from the Ministry of Natural Resources and Forests. Thank you.
Thank you, Councillor Michelli. Anyone else? One thing I just wanted to point out, I found this great article today, actually, was in regards to Ottawa. I mean, everybody's experiencing this across the province right now. And one of the proposals, as you all look to contact your local MPP, would be, in some cases, I guess there is an exemption that exists for any land licensed by the M&R as quarry operations or gravel pits. And so their suggestion is that, independent of other proposals, any land currently being used for agricultural purposes should be exempt from provincially significant wetland designation. So there's actually a couple of other proposals in here as well that I think deserve some merit. Another one in the context of residential areas, it says that the city and province could change the zoning regulations to allow the owner of a property zoned as rural residential to modify up to 25% of his or her property without triggering environmental issues. So, there's different alternatives there that, as, we're going to need your help, I think, to be able to lobby the province to make these changes. It's not something that's, on just Norfolk County Council here, that we're going to have to work together to be able to move this forward. So, with that, again, if everybody could keep it short, and you'll have your opportunity to say your piece. If you could listen to what everybody's saying before you and not repeat what the previous person said. We're going to try to keep it to a maximum of 5 minutes, constituent this evening, if we can. And again, you don't need to speak if you want to just sign the piece of paper. If you feel your neighbor has spoken on your behalf, sign the paper, and that will be enough to preserve your rights of appeal. So with that, whoever would like to come forward first. Yeah. Councilor Michelli?
Thank you, Madam Mayor. I'm just wondering, for those who want to sign the paper, where is it?
Oh, right there on the podium.
Okay, thank you.
Maybe we could set it right back there in front of Mr. Judd, and that might make it easier.
Sign up for the right to appeal, we can do so here, and this is for anybody speaking two separate lists. And that, both of them.
Okay, and also for the purposes of efficiency, if we could have the next person always queued up and ready to go.
Mayor Chop, Council, County members, I'm Sue Bamford. I live at 42 Willow Ave. We have about 360 feet of seawall. We are in a subdivision that was divided or built about in the 50s. We have a working channel. In fact, we're on the takeoff. And 5 of the lots on the Willow Ave Poplar that we share have been designated provincially significant wetlands. I've had a surveyor tell me, don't let that happen. And I've asked Ron DeBrebrick what I could do, like, can I repair my seawall? Can I replace my seawall? Can I always use it as a channel? We have had to have those channels dredged, which we property owners went together and paid to have them dredged. Can this happen in the future if provincially significant wetlands is put on that section of the channel? There are several channels it's not on. And we're wondering why it's on those 5 lots. And why did they stop where they did stop on that channel? It's the takeoff for the whole subdivision. It handles poplar, teal, willow, and pickerel, all in Long Point. And Ron can't answer me that. He can't answer whether in the future we can maintain that. Now, Ashley Call did say, I could always, if my place burnt down, I could always build it on that lot. But now, that speaking, she did give me a paper on that, but does that hold up if I ever wanted to do it in the future?
Unfortunately, tonight, I don't think we're going to be able to address individual questions like this.
Okay.
At this point, it can't be about individual property issues. It's really as to whether or not sort of the map database is correct in
Well,
regards.
Tom Michelli brought up a good point, because when I talked to Ron DeBrebrick, he said, Sue, it's unfortunate that the mapping is not always correct. Well, so when I asked him what made a provincially significant wetlands, he said the plant life. I said, this is a working channel. people are going in, there is no plant life in it. And he said, well, to get it changed, you could hire somebody, so that means pay, to have taken off what was never on when we bought the place. We've been having a cottage on these channels since 1968. Why is it put on now? Okay, do I sign this then? Do you have anything to say? Yeah.
Councilor Shelley.
Thank you, Madam Mayor. Mrs. Bamford, thank you very much. I just want to mention, to add to that, and many of the people in this room are aware of this, many of the things that are required in this provincially significant wetland legislation really require, like the suggestion is, well, you could pay somebody to take care of this. So what we have really, which I think is really unfortunate and honestly a bit ridiculous, people who pay property tax can pay more money to find out what the deal is with the property, or with the property they pay tax on. Also, just kind of connected to this, and I'm just going to mention this once, the environmental assessment, impact assessment that has to be done in many cases. I know that that costs a considerable amount of money, and again, somebody gets to pay more money to find out about whether or not they can use the property they already pay tax on. So I appreciate your comments. Thank you.
Thank you very much, Tom.
Thank you.
Mayor Chop, committee. My name's Helen Gilmore. I have property at 36 Willow. I also have property in Oxford County. Now, back a number of years ago, I was talking to one of the councillors over there, and they said that this same situation arose in Oxford County he didn't tell me how many years, but back years ago. And there was, again, so many people like here opposing it, and the township eventually threw it out, and they disallowed it completely. So would it be a consideration for our township to disallow it and it get thrown out? Just a consideration.
Okay, if we could just, again, have everybody queued up and ready to go so we're able to, Councillor Van Pat, we're not going to be able to keep doing this in between each one, but.
This might help with that last comment there. And this is the problem we have. We can take it out of our zoning bylaw, but it will still exist. They are provincial regulations. We are just putting their regulations in our bylaw. So if we don't include it, they still exist. You still have to follow them. We got to fix the source of the problem, which is the MNR.
I agree with them. I'm Mark Gilmore. I have a cottage at 36 Willow Ave. I think the big thing that everybody's so upset about here is that we're kind of getting this rammed down our throat, or it feels like we are anyway. And the other thing is that, everybody has a million questions. What's involved? All of a sudden we got this PSW mapping, and nobody knows what you can do and what you can't do. And I actually think that the Ministry of Natural Resources, they knew, we have called them numerous times over this, asked them a lot of questions. Nobody's got any answers. And I think that's what everybody's so upset about. Nobody knows what's going on. They're just going to pass a whole bunch of stuff, ram it down our throat, and then 2 years down the road, you go to get a building permit. What's happening? You're just, nobody knows. So I think before you should pass all this stuff and make it part of the official plan, I think the MNR should come and defend their position. Because maybe some of these maybe people don't agree with the PSW mapping, and maybe they need to go back on an individual basis and look at it. That's all I got to say. Thanks.
Thank you, sir. Next.
Sky Bowen, 575 Second Concession Road, Langton. I got a question. With all these changes of zone boundaries and all that, is there any mention of compensation for farmers that lose acres of land that they can no longer farm? There's down Houghton County, or Houghton Township, I guess it is now. There's a lot of that land that's underwater for 3-4 months of the year. And what are you supposed to do? You know, in the springtime it dries up, and when it dries up, you get out on the field. But, you know, I had a farm, another farm, and, you know, I had 3 feet of water in my basement. So, I mean, in theory, my basement could be considered a wetland. The whole property was a flood. But, you know, it went away in the spring, most springs. Some springs were earlier, some springs were later, so. But I think that needs to be considered.
Definitely. There is a tax relief program that I am aware of.
Tax
but